God. Okay. Now, we interrupted a question here. What was the question that we interrupted?
The question is, what was the question?
Who asked the question?
I believe the lady back here. Didn't you?
That was Brett.
She'll never
Oh, I see. I know. We were ready for the next item on the list here. All right. So you have on your points and authorities, you have the point being made, the authority supporting the jurisdiction, or the applicable law, whatever it is, and you don't have to just quote law. You can quote cases, you can quote philosophy, you can quote the Bible if you want, all the moral support. But these are authoritative sources, which aren't, maybe they're binding, maybe they're not on the tribunal, the judge, whoever the judge may be, even if you're the judge, the tribunal. But this is where you argue your case. Just like if you were in front of a jury and you are arguing your case, you're saying, here's why you should decide in my favor. So that's where the argument, item 4C, that's where you jump up and down and beat on the table or whatever. Oh, which reminds me of an old legal saying, that when you have a strong legal case, you beat on the judge. When you have morality on your side, you beat on the jury. You pound on the jury. And when you have neither the law nor the morality on your side, you pound on the table. So, anyway, on 4C, this is where you do all that stuff. You argue your case, just like you're talking. You talk on paper. All right, so now we have the proof of service. Okay? Now, more and more, the courts are going toward mandatory forms. And right now, if you file an original lawsuit, you get a summons. It is mandatory that you use the proof of service that's specifically designed for a summons. Okay? Well, it's okay. It doesn't really affect your rights. You can do that. But watch out for these forms because, again, you don't want to be in conflict with the clerks. You want to work with the clerks. And these forms are usually okay. And if you do have a form that they love for you to use, but it doesn't quite fit, all you have to do is, on the appropriate item, all you have to do is say, see attachment. And then you take a blank sheet of paper and you put it with it. That's your attachment. And then you say or do whatever you're going to say or do. Okay? So that's all it takes for that form. Or any form. You can always modify it. They don't seem to have much rules against modification as long as you do it by attachment. On some forms do have an attachment form. So if you have more to say, apparently on these forms there have been enough variation that they couldn't get around. They actually made up a form for a variation to the form. Okay? It's called an attachment or addendum or something like that. So anyway, but you make a proof of service. What I'm going to show you here is a general proof of service that we used to do. It's the old way of doing things. So, and I kind of like it. It gives me a little flexibility. But a normal form, an actual form from the Judicial Council does work. That's why they make them. So here it is. This form is what I often do. You'll notice that there's no caption on this form. Okay, there it is. That's the whole form right there. Basically, a form, a proof of service, is simply another affidavit. Okay? How does the court know, how can the court have confidence that you delivered the paperwork? Okay, here's the tribunal sitting here, and the question before the tribunal is, did everybody be properly notified that this is going on? And if you have a proof of service, that is what the court is going to use to determine that everybody has been properly notified that they have an interest here. Okay? That's all it is. So here it is. It says, I am employed in the county of Orange, state of California. I am over the age of 18 and not a party to the within action. All right, that's important. Not a party to the action. You cannot mail, serve, or in any way give your papers to the opposition or whoever's interested, yourself. You have a vested interest in winning your lawsuit. Therefore, your proof of service is no good if you signed it. You have to have somebody who is at, as they say in legal language, who is at arm's length, okay? That person has no interest in the outcome of the lawsuit, no direct interest, and so is therefore more trustworthy. When he says he delivered the paper, then you know it's so. Now remember this. Let's say you serve somebody by mail, which you can do. Once you have somebody in jurisdiction, you can serve by mail. But you have to have somebody, again, third party, who's not connected to the case. If you're married, you're suing somebody, your spouse can serve the papers. Okay? The spouse has no direct interest in it. Indirect maybe, yes, but not direct. So it's legit to have your spouse serve the papers for you, or your girlfriend or boyfriend, or whoever, okay? Just don't do it yourself. No party in the case can serve the papers. So you're declaring here that I'm not a party to the action. My business address is such and such. You can use any address, you know, home, business, doesn't matter. I have to warn you about one thing. If you're going to make a habit of serving papers, then the state of California requires that you register as a process server. Okay? That's one of their little requirements. Doing an occasional service for a friend or something like that doesn't qualify. And I believe that if you don't charge for it, then it doesn't qualify for regulation. It's only when you're charging for it, you have it as a business. And I forget what the criteria is, but there's some criteria, and it's on the forms, by the way. I think it says, I certify that I have not served more than so many per year or something. Did anybody remember that? No. Anyway.
Yeah, it's, you're not allowed to serve or pay more than 10 papers per year.
No more than 10 papers per year, okay? So that's cool.
Yeah, you're quite correct. You can serve as many as you want.
Yeah, for free, you know, you're not in the business. That's a different story. But there, anytime you start getting engaged in commerce, guess who wants to regulate it? Okay? So anyway, that's the only warning is that if you're going to make a habit of it, by all means, then consider the fact that you may have to register.
Bill, is there any problem with changing the word within to the place that we're action and vice versa? So it reads a party to the action within.
They can't hear you back here.
Okay, he's asking, can we change the words around? Well, yeah, you can change the words. I mean, you know, all you have to do is speak English. You know, plain English works.
Isn't changing it around better understood? I mean, isn't it?
Well, maybe for you, I understand it perfectly well. But, you know, well, if you understand it and I understand it,
Okay.
you know, sure, you can always rewrite things. There is a formula which was stated by Mark Twain, a.k.a. Samuel Clemens, and he provided the surefire rule for good writing. It was revise, 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 revise. Okay? When you have 7 revisions, your writing is bound to improve. That was his rule for it. So sure, I'm sure we can improve this with a little extra revision. Anyway, but this qualifies, all right? On November 24th, 1986, I served the foregoing documents described as, and I name every single paper in it. Okay, the application for substitution of plaintiff, the declaration, the points and authorities, the order for substitution. It's actually a proposed order. And I guess something like that, whatever. On the interested parties in this action by placing a true copy thereof enclosed in a sealed envelope with postage thereon, fully prepaid, in the United States Mail at Anaheim, California, addressed as follows. And then I list every single address that I mailed to. Okay? I am, you give your own name, okay? I have personal, no, the person who's doing the serving. I am so-and-so, I have personal knowledge of the above facts, and am competent to testify as to the truth of those facts if called as a witness. I declare under penalty of perjury that the foregoing is true and correct, and that this declaration was issued in Anaheim, California, November 24th. And it's just an affidavit is all it is, saying what you did. And we've had complications in service. You know, I'd serve somebody, and this person would pretend to be somebody else. You know, you have these games. Hey, when I'm doing service, I put that all in there. I say, this is what happened. Well, what does that do? The court looks at it, and they say, well, that sounds reasonable. Yeah, we think the guy was served. You know, it's okay to tell the truth. It's amazing, you know, what they do. But let me explain something about service. Service is kind of interesting. There are different ways to serve people. And the biggest thing is getting the first service, because once you have somebody in jurisdiction, then you can serve by mail. But before you can serve by mail, they have some standards for service. So the highest quality of service, there's levels of quality. And the court is aiming for the highest quality, of course. So given first choice, the clerks would prefer that you have a third party go over and hand it to the person and say, you are served. Okay, this is a lawsuit. That's all you have to do. And they don't have to take it. You know, if somebody comes back and refuses to take it, you've already informed them, right? You just drop it at his feet and walk off. He's served. Okay? Don't worry about formalities. Don't worry about getting them to sign a receipt. You don't have to do any of that, okay? You just take it and say, are you so-and-so? He says, yeah. Well, these are legal papers. You're being sued. You don't want to take it? Drop it on the floor and walk off.
That's right.
Okay?
That's exactly right.
That's right. You don't, he has been informed. That's all the court wants to know. Yes?
Before you can revert to substitute service, what procedures do you have to go through?
All procedures are substitute services except the one I just told you.
But before you can rely on substitute service, what do you have to do?
You don't have to rely, no, you don't have to do anything. You can do substitution of service if you wish without any other effort.
So you're not required to personally attempt
No.
to serve?
No. No. You can, what you can do is, you see, there are the first two levels, either way is good. Okay, you can do service or you can do substitution of service on the first two levels. The first level is what I just told you. You've had personal contact with a person, and you just drop it on the ground if he doesn't want it, or leave it on the counter. You know, a lot of times we serve courts. We serve judges. We go right in. The marshal's there. You say, this is legal service. He's the gatekeeper. I can't get to the judge. He's the person apparently in charge. I just hand it to him. I say, hey, and this is the second level, actually. Okay? If you can't find the person himself, then the second step is you give it to the person who is apparently in charge of the office.
Even if you don't know his name?
Even if you don't know his name. Okay? You don't have to know his name. What you do, ideally you want his name. You say, on such and such a date, I served somebody with these papers for so-and-so, or whoever it was for, okay? And you give it to them. They know if they're over 18 years old, they're assumed to be responsible. You give it to them. It is their responsibility to hand it to the next one, and it's prima facie assumed that he will give it to that person. However, the courts recognize that that service like that is not as good as personal service.
Do you need that person's name?
No.
Who was left with?
You don't need the person's name. All you have to do is describe the location, describe the person. If you don't know his name, say, well, 5'2", eyes of blue, okay? Age, weight, you know, a description of the person and what time of day it was that you were there, so that if the question ever comes up, you can pinpoint who that person was. Because ultimately you're going to get to somebody responsible in that house, and they'll know who that person is. You see? So they can't dodge it that way. They don't want to give you a name? Okay. I got the description. I saw who you were. I saw the hair you had, the clothes you were wearing, the approximate age, weight, color, eyes. You know, I get all that. Or if you can't get all that, you can't remember it all, get it as close as you can. But the courts recognize that that is not quite as good as personal service. So the courts require in their rules a secondary simultaneous procedure. You mail it to them. Okay? So when you hand it to the person, it's a targeted service. When you do the second level service, it's a two-shot service. One is the giving it to the adult who's apparently in charge of the office or responsible for the home, and the other one is mailing it to the same address. By doing that, you now achieve the same credibility. The person cannot say he didn't get it. Now, as a little side note, do not send it by certified or registered mail. Why? Because when they refuse it and it comes back to you, that becomes proof that they did not get it. The courts presume that if you mailed it, they got it. The post office is basically trusted. Okay?
Right.
So do not send it by certified, or if you want a little receipt, you can get a receipt from the post office saying you put it in, but once it gets into the postal system, it goes, and there is no, the burden is on them to prove that they didn't get it. I don't know how they would prove it, but they could prove it. Yes, sir.
If you do certificate of mailing,
Yeah. You can do a certificate of mailing, that is true, but because that does not inhibit the process. They cannot say that, you see, with a certificate of mailing, all you're doing is getting a receipt from the post office saying that you handed it them. But again, it's not you personally. You want a third person who's at arm's length, who does the actual mailing, who does the actual substitution of service process, and he makes up a proof of service saying that's what he did.
With a certificate of mailing, the postal office will always say they have to fight the post office that it wasn't delivered. It doesn't come back on you. It goes on the post office.
Yeah, whatever it is, I'm not sure how you prove you didn't get something when it's mailed openly like that.
There
Yes.
Well, I'm just going to finish this up. There is a code that's under, geez, I can't remember right now. But anyhow,
Yeah.
it says that they can, under certain circumstances, accept certified mailings if upon a signed receipt for delivery. In other words, somebody signed for it, and you get the green card back.
Oh, well, yeah, if they got it, that saves all argument. I'm just saying that don't send it, because if they refuse it, it becomes proof they didn't get it.
Yes, but is it actually proof that they were properly served if
No.
somebody signed for
Well,
the
if they
receipt?
sign it, no, it's not necessarily proof. The proof is in the proof of service you filed that it got mailed.
Okay.
That becomes backup evidence. That's not the basic evidence.
Yeah.
Because, see, the person signing it and the receipt comes back, that's not proof of what's in the envelope. That only proves they received something. You need the proof of service that you actually put it in the envelope, you sealed it, and you mailed it,
Well,
and how it was addressed.
without, in this case here, they're not accepting that as proper proof of service.
What do you mean
Even
they're
though
not?
it has the proof of service, the affidavit that it was properly served, and the postal receipts, including the green card with the signature on it.
Look,
The court's not allowing it.
all that green card does is give supplemental evidence. The real evidence is in the proof of service made by the person who dropped it in the mail.
Yeah, they're
That's
claiming-
if you do not have a proof of service and all you have is the green card, that's not going to work, because all the green card proves is that they received an envelope. It doesn't say what the content was.
No, we had the proof of service too. That's not the consideration.
Well, the proof of service is all
They're
you
saying
need.
it doesn't matter, certified mailing with proof of service return and the proof of service.
Well, what's your point then? If it doesn't, I'm missing something here.
I'm just trying to get your view because the court said no,
No, what?
that's not sufficient service.
What's not sufficient service?
Certified mail with proof of service return attached to a proof of service form.
But if you
Yeah, well, again, yes, the receipt that they signed for something is definitely not, that does not stand alone at all.
But if you put in your proof of service that the individual who is mailing it states that I placed such and such a document, so many pages into the mail, and you specify a post office address, physical
That's right.
address.
That's right.
If you
All there.
include that in your proof of service,
was all
the
there.
court will accept that.
Yeah, that's all it takes.
No,
In
it-
your proof
All
of
right, now,
service.
hold on a second. One thing before we get out of control here. If you are opening up a brand new case and you're serving somebody by mail, yes, that is a problem. Okay? If you just serve by mail, that is a problem. Okay, so that's not really going to work well. The courts have flexibility in deciding whether or not service was sufficient. Okay? There is some flexibility, but proof of service is pretty narrowly defined in that basically you have to have the proof of service, and if you're doing a substitution process, it's a physical delivery backed up by a postal delivery. The two in combination make the service valid. If you only have one half of the leg, it isn't going to work. Okay? And it could work if you have a special circumstance, all right? But it has to be very special. The court is authorized to make some exceptions to it, all right? And I'm going to get further down the line. There's more to the story. But basically, the proof of service is a two-pronged effort if you cannot find the person directly. All right?
Or if you have defendants in multiple states, and it's maybe physically impossible for you to do your own physical service.
Yeah, there are exceptions, like I said, and there's a lot of discretion on the parts of these judges. Now, I haven't gotten into those problems, so I cannot speak with authority. But I will tell you this, that this is all in the rules of court or in the civil procedure somewhere in there, okay? So you just look up proof of service, you'll find it.
However,
Right.
to also, like, it's like she said, it's like Pamela said, if you have someone who will testify that they delivered these documents in and mail that should be sufficient to take care of the problem with the green card that you just talked about.
Well, you don't need the green card.
Right,
okay?
I
but
think
this will take care of that.
I think we're getting off track here. I worked for an attorney as a process server, and what Bill says is true and correct. On the first serving of a case, you serve the person in person. You don't do it by the second means. You have to get them served in person. If the case is already a going case, then you can serve them second process.
By mail.
By mail.
And only by mail. You don't. That's all you need.
And if they're if they're in other states, then you have to find a process server in that state that will serve them. That's just the way it is.
Okay. Now,
Okay.
but let me say this, that like I said, if you have an exception, you can always go to the court and make a motion. Okay? You can make a motion asking the court to acknowledge that this is good service.
That's right. That's
Okay? So you're not stuck. But there's more to the story if we can get past this point. So far, we've got two levels of service. Yeah, you have something?
Also, on the fact of going on to the second level, you need to do at least diligence. I found an affidavit of diligence we've knocked out where they haven't filed proper affidavit of diligence or had flawed statements in the affidavit of diligence, in that they attempted 3 times to serve personally and were not able to. If you can find flaws in that, you could pick it apart and throw it out. If they don't have that and they go to the second level of service, you can also knock it out. I have done that personally. As far as other states, you often can get a sheriff to serve for you, and you just find out who the local sheriff is, ask what their service is, and you can do it through them. I've done that a number of times also.
Yeah. But look, the basic concept is that you serve them personally the first time, and if you can't do that, then you can serve them with substitution of service the first time. It's okay. You don't need special approval procedures to be able to leave it with the adult that's there and then mail the second copy to them. That works for an initial lawsuit. Okay? After that, you can do just mailing. Okay. But now, here's where the fun starts. We have another level, okay? And that is that let's say that you go to the place where the person lives. The lights are on, the door is locked. Of course, you're not going in anyway, but you know, you knock on the door, there's no response, but you know he's in there. Okay? You can go back and petition the court. That's another motion, by the way. You can petition the court to break down the door, okay, to use a forceful service. If the court authorizes it, you take the authorization to the sheriff or marshal. They will go over and bust the door down and serve the guy, okay? But you have to certify that he's hiding in there. All right, so that's another technique. Another technique is that you can serve by publication. And you have somebody that you know he's around somewhere, but you can't find him. You simply don't know where he is. Now, the courts do not like service by publication because, I mean, who reads these legal notices, right? But technically, that's how it's done. But you go to the newspaper, you publish like so many repetitive times, so many weeks or whatever. You serve by publication, and now the court will recognize that. But before you can serve by publication, I think that on that case, the courts do require a statement of due diligence. You got to show that you really tried, that this guy, you can't find him. All right? So that's another technique. Another technique is to have the clerk do the service, in which case the clerk always does it by mail. I'm not sure of quite what the circumstances are for that. I've never done that, but I know that system exists. Finally, push comes to shove. You know the person is somewhere. You just don't know where. Somewhere in the state, maybe. Could be in Northern California. You're in Southern California. Where is this person? You don't know. All you know is his name, maybe, where he used to live, maybe, something. So what you do is you serve the Secretary of State, and the Secretary of State is responsible for finding him. Okay? Now, how that works, I don't know, but I know it's in the rules. Okay? You can serve the Secretary of State as a last resort. So, it is not possible for anybody to hide from a lawsuit. You will end up with a judgment one way or another if you follow the procedures. Yes?
I went to serve a county sheriff, LA County Sheriff.
Sure.
And he would not tell me where his office was, so I went to the headquarters.
That's the best thing to do.
And I took it and I asked for the person who accepts the summonses to come out, and they did. And they came back and said, well, he doesn't work out of this office. He works out of another office. And they gave me that office, and we called, and he wasn't there.
Uh-huh. But he doesn't have to be there.
So I know. They said he did not work out of the other office. So if I went back to the headquarters, I could maybe give it to any officer. Is that right? Who is coming in and out of that office and get them served?
No, it would be anybody who appears to be in charge of the office. The phrase is apparently in charge of the office. Doesn't have to be in charge, but is apparently in charge. If you run up against the gatekeeper, that person will not let you pass, then that's the person apparently in charge of the office. That's all. You can ask for the manager. If they refuse to get the manager, obviously the person you're talking to is the person apparently in charge of the office. Got that word apparently. That's all you need.
Okay, well, where I went is on Temple Avenue, on the 9th floor, where it is locked, and you have to have a plastic key to get in.
Well, that's fine. If they isolate themselves, you just go back to their boss, you know. You're serving the sheriff anyway.
You go back to the
Well,
where?
that's right. You're serving the deputy. But you see, look, you go wherever he works out of. If you know for a fact he's a sheriff, then you just go to that office where the headquarters are, right? Because they're in charge.
Right.
Right? They certainly know where their people work. And if they're playing the hide-and-seek game, that's no big deal. You just go back to headquarters, you drop it off, you say, this is for this guy, and then you mail a second one there because, after all, that's where he works. And that does it.
Well, they hoodwinked me, and I didn't give it to that.
Well, that was today.
gatekeeper.
Tomorrow it's different.
Okay, so I can do it again with him.
Sure, sure.
Another trip.
No, that's all right. It's good for you. All right, so you see, so you have your different levels of service. But whatever you do, you make up a proof of service. Okay? In other words, you just describe what you did, and you declare that this is, in fact, the truth that you're telling. This is what you did. And now they're served. So those are the levels of service as I understand it. And all of that is described in these books. If you look at the Rules of Court, California Rules of Court, or you look in the Code of Civil Procedure. I forget where it is, but it's in there. Okay? Just go to the index and look up proof of service. Now, okay, speaking of rules of court, as a little side note, there are 4 sets of rules of court that you need to understand exist. Okay? The first rules of court is not actually rules, it's code. If you look in the Code of Civil Procedure, it describes service. Okay, you got to read that section to get the full flavor of it. The second set is called California Rules of Court, or CROC for short. I'm not joking. It is CROC. Okay? California Rules of Court, that's the big book. That's fairly thick. Then you have the local rules of court. That's your third set. So you go to the particular county that you're in, whether it's the Superior Court or the Municipal Court, which doesn't exist anymore in most counties, or whatever court it is, you go to that court, to the clerk, and you get a copy of the rules of court there. So those are referred to as local rules. Okay, so you got the state rules of court, California Rules of Court, you have the local rules of court, and the Code of Civil Procedure. The fourth set of rules is usually just 1 page. And it's the rules of the particular judge's court. And it's something like no chewing gum, during court and session, cell phones shall be off, the little stuff. But it's typically about 1 page long. And so you really ought to find out what the rules are there too. So whenever you're dealing with rules of court, remember there are 4 rules of court.
How do you get a tape recorder in past the guards?
Court order, you go to the court, you make a motion.
Oh, really?
Yeah. Remember, understand this. What I need for you to do, I think I need to remind you of something back here. Okay? Let's get off here. Because your question tells me that you forgot this. And I know everybody forgets it, including me. So I'm going to go back to this. I think it's the foundation. Yes. This is a quote by Cicero. Wise men are instructed by reason. Men of less understanding by experience. The most ignorant by necessity, and the beast by nature. And this is Cicero, okay? Now, this court of record stuff that I'm talking about requires you to be on that first line. Wise men are instructed by reason. You have to have, or if you don't have it, you better develop it. If you're going to successfully use sovereignty as your foundation for what you do, you've got to learn to reason. If A is so and B is so, then C must be so. Okay? You've got to go through that logical pattern. A lot of people, I'll tell them about how you make motions and so forth, and then they say to me, show me an example. Now, seeing an example is nice. It helps to shape things. But that's secondary. The primary thing is that you need to know that if you're a sovereign, and you're the sovereign of the court, you're the plaintiff, and the court consists of the person in suit of the sovereign, wouldn't you conclude that you're in charge? By what authority do the people you hire presume to overrule you? I'm talking about judges. Okay? You've got to reason this out, because if you don't have that reasoning process, if you have to sit around and wait for experience to hit you, if you're on the second line, then this is not going to work for you, because a lot of times you're getting hit with something unusual. Why? Because you hit them with something unusual, and you don't know how they're going to react. And so you have to be able to get a clear understanding of what it is that this is about, have the right perspective, so that you automatically come up with the right answers, okay, from A. Now, here's how you do this. When I started out, my biggest question, I was just like everyone else. I said, okay, the theory's nice, but how do you do such and such, whatever it is, okay? Took me a long, long time to get past that stage, because why? I was living by experience, and I would glom onto examples of motions and things that people did before I found this general pattern, okay? But the bottom line is you have to be able to say if something's so and something else. You got to trust your theory, okay? Because there's not much examples on a lot of this stuff. The very first order that I ever issued in court, it wasn't even my case. I was issuing it on behalf of someone else. I was operating on raw theory. I didn't even have examples or experience or anything else from anyone. I had just concluded it from pure, unadulterated reasoning process. And I didn't know if I was going to end up in jail or not. Okay? But there was a guy that was in jail, and I determined for my own satisfaction that he was a political case. He was being persecuted, okay? And I decided to get involved. And he understood sovereignty. He protected himself well. And he was being held by the municipal court, and he moved for habeas corpus from jail into the Superior Court. This, by the way, was in Redwood City. And so he put in his handwritten habeas corpus, and the Superior Court judges just routinely denied it, okay? But you see, he knew it was his court. So I went up there, and I agreed that I would get involved. And so the first thing I had him do, because he was sovereign and it was his court, I had him appoint me as a special master in his court. Now, special master is like a judge without the pay, okay? And I had whatever authority he granted to me as a sovereign. And by the way, that's all a judge can do, whatever authority the sovereign grants him. So he granted me the authority to investigate, inquire, to take depositions, okay, and to do whatever was necessary in order to move the process along. But I still did not have the authority to make final judgments, all right? So that was on a Monday. I went down, I filed it, you know, got immediately upon filing, got several certified copies, because I thought I might need that, such, you know, in the Superior Court. I went over on the following, or during that week, there was a rumor, jailhouse rumor, that he was going to be pulled into court on Friday morning. So we took that seriously. I prepared an order halfway, and I went down to the court, and before the court session started, I got an audience with the judge. I, again, dressed like an attorney, okay, nice pinstripe suit, etc. And I explained to the judge that I had been appointed, this is municipal court judge, that I'd been appointed as a Superior Court master of the court, special master, and that when he called this particular case, that I would be there to observe the proceedings. And I showed him my paper, which, by the way, had been signed by the prisoner, because he was the sovereign of the court. See, and I had his seal, by the way. It was signed, it was sealed, and it was filed. So he acknowledged it. When he called the case, I stood up, and I was standing right between the public defender that had been assigned to him, and the prosecutor was on my left. And at some point, I got an opportunity to start talking. And the judge and I went back and forth, and I explained to him that there were that who I was, and I said I'd been appointed as a special master of the Superior Court, and that I was here to observe the proceedings in this particular case in the municipal court. And I said I'm here now declaring the Superior Court of the State of California open and in session. So here we were with 2 courts and 1 courtroom. Now this was all on raw logic. Again, I thought my way through the problem, and I understood habeas corpus. It was the prisoner's court, okay, in the Superior Court. That Superior Court outranked the municipal court, part of the same system. So I figured I outranked the judge. I had greater authority. So that's how I presented myself as a Superior Court special master. So we started talking about it. I said that there were certain issues involving common law rights, and the judge informed me that the common law had no standing in this municipal court. So I agreed with him. I said, yes, Your Honor. I said, I agree. That you are correct. But I said in Miranda versus Arizona, the court had said that where substantive rights are concerned, there shall be no rulemaking. Okay? You cannot legislate either for or against substantive rights, common law rights, in other words. Change the word, but it's still common law rights. So he agreed, yeah, that was true. So we had a little pause there, and I always like to tell this story. And during the pause, the prosecuting attorney stood up, district attorney, and she said, Your Honor, who is this man? I don't know who he is, and I don't know what he's doing here. Now, you know the judges and the prosecutors are pretty much in bed with each other, right? The judge just sat there and stared her down. He just looked at her, didn't say anything. Finally, she sat down, and then he turned back to me and picked up on our conversation as if she were not in the room. Can you imagine that? Well, I'll tell you something. Up until that moment, I was running on pure reasoning process. But when I saw how he mistreated that prosecutor, how little recognition he gave her, my knees stopped shaking. I knew I had struck gold here somewhere, okay? Maybe I didn't understand exactly why, because I was still on theory. But there was something going on, because why else would a judge give a third-party, intervening party, the time of day, right? And why would he ignore a prosecutor who we know he works every day with, and would give the respect and so forth? Doesn't even respond. She was like out in left field as far as he was concerned, I guess. Anyway, he said to me in his conversation, he says, well, what is it that you want me to do? Again, I was a special master, so he addressed me personally. He says, what do you want me to do? Well, because I was a special master representing the court, I could not tell him what I personally want him to do, which might have been to go fly a kite or something, okay? So what I did is I stuck with the theoretical script. I'm here representing the court, so I'm going to tell him what the court wants, okay? So I said to him, it is the wish of the Superior Court that the municipal court release jurisdiction of this matter to the Superior Court until such time as the issues in the Superior Court are settled. And he said, I will do that if you will give me the order in writing. And I said, now I could speak personally. I said, well, I came here with an order half written because frankly I didn't know how this session would go. But if you will recess the case, during the recess I will prepare and complete the order and deliver it to you when you recall the case. And so he did that. And boy, was I rushing around, writing it out by hand. First half was typewritten, the second half was handwritten. And I got copies made and, the whole bit, and came back. When he recalled the case, we passed it through the marshal up to the judge. and the judge read it into the record and then ordered the paper filed into the record, and then he terminated the session, and that was the end of the business for the day. Now, I know he was going to research it and see whether or not he could put me in jail, okay, but nothing ever came out of that. We progressed to the next point. But I thought it was interesting, you see. But how did that all come about? Because I had no prior examples. Raw logic, raw reasoning power. You've got to somehow acquire that skill. Now, I'll tell you frankly, it's not easy, okay? Not easy at all. But there's a method that I recommend to you for doing it. I've given you these highlights. We've been here all day on this stuff, okay? I've given longer sessions. But the key to picking up on this is group action. Pick a case. Pick the most serious case you got running in your group. Get 3 or 4 together and actually group think on this thing. Because what one person forgets, the other will remember. It's amazing what you can dredge up out of your memories if you have the group working on it. You produce those papers, and the mere fact that one person explains something to the other person will crystallize the concepts in your head, will cause you to dredge up things that you thought you forgot. So that's my recommendation. You absolutely must work together. None of this entrepreneurial, independent stuff. You've got to work together. Invite your friends. It's really critical. It does not work when you go it alone, when you're just learning. Okay? Here you are, a bunch of you. I don't know, pick your friends, work together, because this is how you learn. This is how I learned. I learned by teaching. And I got involved with over 150 cases. And I can tell you, working with different people, people ask questions, and I say, oops, you know, I never thought of that before. Or maybe I did think of it before, but now I have second thoughts that are better. So group action is the key, okay? All right, so any questions about this? All right, well, let's see. We have... All right, let's see. We have procedure, right? Back to procedure.
This might be a good time to switch to audio tape.
Oh, sure. Okay, time out for tape change. Now, we have, I'm back at the home page of this CD. This is the law notes, and we have the reference law books, all right? Now, you've heard me talk a lot about Matthew Bender's books. I made some excerpts. My understanding of the copyright law is that for educational purposes, you can copy sections and so forth, you know, and that's what I've done here. And I have not copied everything in Matthew Bender that they have to offer. But I'll tell you something, if you take a diskette with you and you do battle with the library's computers, you can, when you do your research, you can copy off of their computers onto your diskettes whatever you need from Matthew Bender's. Okay? It's wonderful. Let me show you what you get with Matthew Bender's. Okay? We have 2 books. We have Forms of Pleading and Practice, and we have Points and Authorities. Okay? So they have the books there, but what I do, for some reason the books are a little easier to use than the computer, at least for me. So I go to the books, I pretty well home in on what I want, and then I go to the computers to actually dig it out. Okay? So I went to 2 parts. We have one set of books which deals with California Forms of Pleading and Practice, and then the other book which is the Points and Authorities, and also argument. Okay? They don't talk about it. It should be Points and Authorities and argument. But they just call it Points and Authorities, or it's also called a brief. Of course, as you know, Some of the heaviest documents around are called briefs. Yeah. But anyway, so let's look at motions. And so here are some specific ones, like a motion to strike. There's a motion for judgment notwithstanding the verdict. You know, like you get a jury verdict and you say, hey, wait a minute. Even if they did decide that way, I want a judgment that goes the other way. And so this gives you the arguments of when that can be done. You can do a motion in limine. Remember, all motions are basically the same principles. But with a motion in limine, basically, you can do discovery on the other side. Now, I've told you that in common law there is no discovery. At least there's no discovery from the defense to the plaintiff, okay? Because you put in all the evidence when you filed your lawsuit. But they don't know that. Even though you're at law, they don't know you can't do discovery, all right? So you do discovery anyway. The attorneys don't know the difference. And if they don't object, it makes it okay. All right? So you do discovery. And you try to get whatever evidence that they have. Well, what if they don't produce the evidence? Well, basically, what you do is you say, wait a minute, this is contrary to the rules of fair play. Because everybody is supposed to be able to see all the evidence first. How you interpret the evidence is a whole different game. That you're not entitled to see until the moment of trial, okay? Strategy is secret, but the evidence itself must be presented, must be released. Okay, so no discovery against you because you presented all the evidence. But on the other side, they're being secretive. So you ask for the evidence. They refuse to produce it. They drag their feet. They just ignore your request for it. So now you have a choice. You can either just go ahead and have trial by surprise, where you go there and then they pop what's the evidence, but that's kind of a bad way to run a trial. Or the other thing is you could say, you could go to the court and you say to the court, hey, this is unfair. I asked for the evidence. They're playing games. They're dragging their feet. They want to do trial by surprise, and I think I should have a fair opportunity to look at the evidence. So now you have a choice. You can ask the court to force them to produce the evidence or be in contempt of court and ask for sanctions because they refuse to produce the evidence. But I consider that a bad way to go because usually the evidence is in their favor. Why would you want them to bring the evidence in if you think it's going to work against you? So what you do, I'll get to you, and what you do is you go the opposite. You say, because they refused, I want an order blocking them from producing the evidence. Okay? Forget it. They can't produce it. Okay? They're not allowed to produce it even if they have it. And that particular kind of motion has a name. It's called a motion in limine. In other words, you're limiting the evidence. Okay? Again, it's just a motion. All right? You're going to the court. You're asking the court to order these guys blocked. Yay or nay, right? That's it. So let's look at a motion in limine. Pardon? Yeah.
Yeah. In respect to this evidence, you also talked about strategy. Let's say you had evidence of documents that were put together of, let's say, 200 pages, which are attachment.
Sure.
You take these 200 pages and you mix them all up, not in chronological order that you would do for yourself, and you hand it to them. This is the evidence.
Yeah,
now
it's up to them to sort it out.
That's strategy, right?
Yeah.
Good.
Now, you're not mixing the pages and they're trying to figure out which page goes with which. Not
Yes,
that.
yes.
No.
Oh, okay.
No.
I just wonder how far this fair
No,
play went.
You don't go that far. But, you know, each piece is intact. This is the evidence, you know, whatever it is. But you let them sort out what's the best order of presentation or what. Let them guess what you're going to do. But I sure like that. Bye. Bye. You know, what a strategy. Powerful, you know. Really strikes at the gut. Yes, sir.
Trying to think here.
All right, we'll take this one here.
Is there a counter?
A counter?
How could they counter that?
Well, yes, as a matter of fact, the motion in limine is right here in Matthews. And when Matthew Bender puts together these things, they deal with successful cases. These are motions that worked, okay? And they take both sides. There's the offense and the defense. All right, so let's look up motion in limine since we're talking about it. Uh-oh. Big trouble. What's the problem? Motion in limine.htm.
What?
It can't find the file. Well, we may be in trouble here. Okay, we have, it's probably there. I probably just changed the name. All right, let's see. We'll go to the folder. Okay. Here it is. Motion in lim. Oh, I misspelled it. It's in limine. Okay. Yeah. I'll have to straighten that out. Hopefully that'll be straightened out before you get your copy. Let's take a look at it. Okay. So Matthew Bender's. Now, I'm going to show you some of the features of Matthew Bender's book here. First, they give you the scope. This is to give you an idea what it encompasses there. So this chapter discusses the motion in limine and its use in civil actions and contains forms of motion and an order granting a motion in limine. That's Form 1s and Form 2. So they actually give you forms. Okay? And they have cross-references. For discussion and forms relating to motions in general, see Chapter 372, Motions and Orders. And by the way, I've included that. Okay. For a discussion of pretrial conferences at which motions in limine may be considered, see Chapter 425, Pretrial Proceedings, which I did not include in there. For a discussion of pretrial motions to suppress prejudicial matter in criminal proceedings, such as motions under Penal Code Section 1538.5 of Deerings, see Irwin, Millman, Monroe, Sevilla, Tarlow, California Criminal Defense Practice, Chapter 23, which is, I guess, published by Matthew Bender. And so these are suggestions, you know, for particular types of cases. All right, so now they give you some education. This is the beauty of it. They give you some education, so you have some idea what they're doing. Okay, governing law. A motion in limine, while common, is not specifically authorized or governed by any California statute. A trial court's consideration of such a motion, however, appears to be authorized under Code of Civil Procedure, Section 128A3, in Deerings, and so on, which states that every court has the power to provide for the orderly conduct of proceedings before it and to amend and control its process and orders to make them conform to law and justice. And justice. Got that? That's where discretion creeps in. You don't want discretion. Keep that a court of record. Remember that. You're the court. But anyway, additional support for a motion in limine is provided by Evidence Code Section 350, which allows the admission of relevant evidence only, and by Evidence Code 352, which authorizes the exclusion of unduly prejudicial evidence. To me, unduly prejudicial evidence means you might win if you show it. Okay, or they might win if they show it. And the judge is there to control the evidence that reaches the tribunal. All right? And I think you're familiar with abuse of that. You've seen that. So, but anyway, so in other words, there's a whole section there that describes the process. Okay, the concepts, the legal. You get a little legal education. It's like a little mini course in that particular subject. Okay, then they give you some definitions. In limine is defined as on or at the threshold, at the very beginning, preliminarily. Okay, at the limit, in other words. A motion in limine is a motion directed to the judge outside the presence of the jury to limit or exclude certain evidence or testimony in anticipation of such references by adverse counsel or witnesses. Such a motion generally is brought at the beginning of trial, although it also may be brought during trial. Okay? So that gives you an idea of where it gets used. What's the purpose of the motion? The usual purpose of a motion in limine is to preclude the presentation of evidence deemed inadmissible and prejudicial by the moving party. The scope of a motion in limine is any kind of evidence that could be objected to at trial, either as irrelevant or subject to discretionary exclusion, as unduly prejudicial. Okay, a typical order in limine excludes the challenged evidence and directs counsel, parties, and witnesses not to refer to the excluded matters during trial, and so forth. So, now, you notice they use the word unduly. Okay? Well, duly, the word duly, D-U-L-Y, means that whatever it is that's duly satisfies the requirements of both the statutory law and the common law. Duly includes both systems of law. When something, if you were duly given a receipt, that means that that action of giving you the receipt will meet the requirements of both statutory and common law. Okay? So watch out when you use the word duly, because you are including the statutory law that you were excluding when you're running your common law case. Okay? Don't just throw words around until you've checked the legal meaning. All right? You can get trapped. And I don't like you guys to be trapped. So, time out for tape change here. We got a little tape change working. Yeah, there's one right here. Unduly means that it would be offensive to both the common law and the statutory law. It's unduly prejudicial. That would offend both the common law jury and a statutory jury, or a common law court and a statutory court. That's what that unduly means to me. The prefix un reverses the meaning, right?
Un is away from, out of.
Yeah. So, anyway, they describe in Matthew, Bender's, they describe, let's see, they describe the purpose of the motion. So you get a picture. This is really, I mean, this is good stuff. It really educates you. So I'm going to skip down to the next part. There's a lot there. See, they do a lot of explaining. You're getting a little mini course in law. So let's see. Appeal. And they talk about appeal after judgment and so forth. Then they give you research guides, places you can look for more information. You remember I got a question earlier. How do you find this stuff? Now you know. Seek and ye shall find. Okay? And this is one of the tremendous resources. But there's other tremendous resources too. So when you go to the library, the librarian will be just like the clerk to say, well, I can't advise you on law. Okay? But if you ask the librarian, where could I find information on blah, blah, blah? Then he will not advise, but he will suggest. Suggesting and advising are two different things. He will suggest certain books to look at, but you take the responsibility of looking into the books, okay?
Say, Bill,
yes.
I noticed in some of your work you take a word like duly and then you explain how you're using it in that case. I noticed in the bottom of the page how you did that.
You mean footnotes?
Yeah, I remember you used duly and put a footnote because it meant something for this page or that word in that case.
Well, you see, one of the rules of good legal work is know thy enemy. Okay? So I know where my enemy is ignorant. And I know what they know. I've studied my enemy. How did I study them? Real simple. I opened up Black's Law Dictionary, 5th edition. It's full of policy and very little law. I look up 4th edition. It's full of law and very little policy. Okay? I got the two side by side. I do compare. I look at this one. I look at the same word in the other one. It's amazing you see the differences. One of the principal things that's stripped out of 5th edition is common law. There's a lot in there still, but a lot is stripped out. That's how I get to know the enemy, because I know the attorneys. It takes a long time for information to get to the dictionary, it also takes the same amount of time for ignorance to reach the dictionary. And so I know that the current crop of attorneys I'm dealing with, they grew up on something in the schools which by the time they got out to practice showed up in the dictionaries that they're using. The latest, greatest, best dictionary. They're on top of it. They have the best of everything, right? They put their money into the best dictionaries, the latest one. The problem is that they don't understand how their mind is being controlled by the available information. They don't know the old books can be better sometimes, okay? And they don't know to have an 1828 Webster's dictionary, okay? So that you know thy enemy. And when I put a footnote on like that, it's because there's a point I know they're ignorant of, and I want them to be educated on that point. You see? So that's when I put the footnotes in. I'm not just randomly educating them. There's a reason I put it there. It's because once they understand what I'm saying, then that in some way is going to affect another thing downstream. Okay? Now, they may skip over it and never read it. That's okay too, because later on downstream, when I make the point, I can refer to this. And remember, failure to object means you agree, right? That's right. I do that a lot. Yes, sir.
Does that CD have both 4th and 5th edition of Black
I can't hear
Swan?
you.
Does the CD have both editions, 4th and 5th, on it?
No, there's Black's Law Dictionary does not appear on this CD.
Oh, okay.
I have, wait a minute, what do I have? I have Bouvier's Law Dictionary on there. That has real law in it. And that's the 1857 edition, I think. Yes, sir.
If I wanted to specialize in writing writs of habeas corpus, writs of prohibition, and writs of mandamus, what would be the very, very best book that you'd recommend?
Well, the first thing that I'd recommend, or if I want to really be technical because I'm in this group that knows the difference, the first book that I would suggest is reading that law note about habeas corpus, explaining the concept that I explained verbally about the two sets of courts and how one court takes from the other court and takes jurisdiction. That's very, very important because you will not find that in any of your books. I got that out of my study of history, legal history. Okay? Well, I read up on habeas corpus and found out from the pages and the pieces of information that came out that was really the story. It was a turf protection tool rather than an actual great writ of liberty. It was the great writ of turf protection. So once you understand that principle, then when you do your research and you pick up on all these things, you'll fit them in a different paradigm. Paradigm meaning a foundation.
Talking about the great writ now in Europe, there was 27 countries just signed a new constitution. Was the great writ removed because now they're operating under the
Well,
UK,
I've never looked at that constitution.
It's brand new. It just came.
Yeah, right.
Just was signed.
I know there was a lot of argument about it. They actually signed it now. All 27 signed on?
Yes, and is a great writ lost?
There's no jury built into that system, you notice.
I know. It's horrible.
Yeah.
Evil.
Well,
They're trying
that's
to bring
okay.
it here.
It'll evolve into a dictatorship. That's what they do. So, I mean, that's historically true.
Wow.
And the United States is doing a similar thing.
And the great writ is lost. Will it be lost here if they pull this off? They're trying to. That's what Bush wants to do is bring us
what
into
they want to do is they want to convert us over to the Roman civil law system. That's why they're stripping the common law out of all the reference books. They still have a problem changing the Constitution, though. See, that's what's stopping them. And if you've got the law, well, then you have the legal power.
But all those 27 countries' constitution has been stripped.
Well, we're not part of them.
I know, but imagine that. The great writ does no longer exist, I think.
Well, that's the problem that people are going to have to deal with over there.
Aren't they stripping the Constitution by treaties?
No, the treaties, any treaties that the United States signs with other countries, according to the Constitution, become the law of the land. However, they do not overrule the Constitution. You cannot amend the Constitution by treaty, okay? it still has to meet the constitutional test. Just because it's a treaty does not automatically mean it supersedes the Constitution. And I have yet to see any treaty that supersedes the fundamental foundation of the Constitution, which is the preamble, which says the people own the government, right? That's the highest authority. They're going to have to change the preamble. By the way, I suggest just, you know, if you want a little entertainment, a little, if you have curiosity, you ought to read the Mexican Constitution. They do have English versions, okay? They actually recognize in the Constitution openly the difference between people and citizens.
Wow.
Yeah, there is a difference. I mean, because they are a republic. You see, Mexico, the formal name of Mexico is the United States of Mexico. And so, and they are a republic, just like we are. That means the people are sovereign, even in Mexico. And in fact, anyone, the Khomeini, Ayatollah Khomeini, when he was alive, he was charged with the responsibility of determining what form of government would be, I guess it's Iran, is it? And he chose a republican form of government. Why? Well, it goes back to the people own the government owns the citizens. So a republican form of government in one circumstance can be the great liberator that frees everyone, you know, because by being a people, whatever the people decide, either directly or through representatives, becomes only advisory to other sovereigns. After all, if you're going to be a sovereign, that means you cannot be controlled. Excuse me. On the other hand, if you successfully complete what they're trying to do in the United States, which is they're trying to dumb down American education, convince everybody they're citizens, give them absolutely no knowledge of the separate stati of people versus citizens, what happens is that now a republican form of government can become the worst form of government, because what happens is the elite are educated, understand they're above the law, right? And the citizens are all subject to the law. And so now you have a dictator, an oligarchy, basically. You know, yeah, right. So if you want to see a republican form of government at its worst, look at Iran, look at some of the Latin American countries. If you want to see a republican form of government at its best, well, I think we've got a pretty good thing going here, you know, because we have educated people. It's true the American system has been dumbed down, but once you rise up above that ceiling of ignorance, where you get up into the appellate courts, you know, these guys understand it. They, when you present your argument, they know. And it was interesting. This is one of the reasons that I've become a patriot for profit, okay? I know that's a pejorative term normally, but I've decided that I'm going to go lecture touring and see if I can survive off of that. Because if I could put on one seminar a month to pay my basic expenses, this will free me up to do some real research. Let me give you an example of what I did one time. I looked at these codes, and I could tell that somebody somewhere has intelligence and is assuring the consistency of the codes. I didn't know where, but I took a guess. I said, one of them has to be the judges, the high judges, you know, Supreme Court and Appellate Court. Something told me that these guys, when I read their writings, you know, I look at their decisions, and I see the reasoning process they go through and so on. So I knew that they knew. Maybe the Superior Court judges weren't so good, and definitely the municipal courts and the small claims courts, that's a bastion of ignorance, okay? But the higher levels, they're great. Then I said, well, look, these laws get passed, the legislature passes them. Well, it turns out that all the laws go through the legislative committee for review. This is where the consistency is assured. That's how they avoid passing bad stuff. So one day, I had some free time, and I drove up to Sacramento because I wanted to research that specific point. How is it that we get this consistency? Where's this intelligence coming from? So the first place I hit was the legislative committee. I went up there and I got a hold of one of the supervisors because I figured, you know, the Indians usually don't know. But I got a hold of a supervisor, manager, who was an attorney, who had never been a judge, but was an attorney, was in the legislative committee. So I said, you know, let's talk it over. So I talked it over with him. I wasn't in more than 60 seconds, and I realized here was another jelly bowl full of ignorance. Okay, this person had not a clue. Okay, so all right, so that considerably changed the direction of my questioning, right? So I said, all right, I got off of that theoretical basis. I got down to brass tacks. I said, just exactly what happens here? How do you work this thing out? You know, here comes a law. I said, I've looked at your work product output, more commonly known as the California codes, and there's this remarkable consistency. What's the process you go through? So he says, well, what we do, the legislature proposes the rules, the laws, comes up with these bills or whatever. We take them and we analyze them. After we analyze them, we have a meeting with the judicial branch. Do I have to say more?
No.
So you see what's happened is that there are in our society only two areas I've been able to locate that really understand these sovereignty concepts. One of them is the high judiciary. They meet with Supreme Court representatives, okay? And the other bunch is random samplings of people like me. That's it. That's where the real knowledge base is. Also, there's other questions that I want to investigate. For example, there was a guy that was visiting Washington, D.C., and he got a ride with a guy, with a cab driver, black cab driver, okay? Of course, there's a lot of black people in Washington, D.C., and, of course, the cab driver was black. And he said to the cab driver, he said, I'd like to go to the Supreme Court, wanted to visit that. And the cab driver said to him, well, he says, over there's the good guys, and over there's the bad guys. He knew there were two Supreme Courts. He was tuned into that, amazingly enough. Well, I'd like to go to Washington, D.C. and do a little research on that, chase down because I know that the Supreme Court of the United States suspended operations for 1 year. I think it was 1 year. It was about, I don't know, back in the 30s or something like that. Or maybe it was late 1800s, early 1300s. What happened? Well, what happened is I think the original Supreme Court is now known as the Supreme Court of the District of Columbia. That's the real Supreme Court. That's the one that Judge Taney sat in. The Supreme Court we have now is something else. And guess what? You ever heard of Justice Souter? By the way, do you know the difference between a judge and a justice? Well, all of those persons there sitting on the bench are judges except the ones that are sitting in the Supreme Courts. They're called justices. And the justices, a justice is a common law judge.
Wow.
A judge is a Roman civil law judge. Okay? That's a rough definition of the two. Well, I'd like to go check this out. Okay? I'd like to check out those two Supreme Courts and see what's what. And I understand that the real Supreme Court has two offices. One is in Washington, D.C., and the other is in San Francisco. I'd like to check that out. Yes?
In some courts, they actually call judges justices.
Okay, well, it's something I don't know. It could be. Now, I do know this, that...
Las Vegas and New Orleans.
Okay, great. I do know another thing. You've all heard the flag issue, haven't you? You know, the gold fringe flag in the courts. Well, a friend of mine was telling me that he was running around all over trying to find some specific court for some specific purpose, whatever it is. And he was going into every courtroom looking, trying to find where the courts were. And I'm sure you've seen in all of these courts in Santa Ana that they have gold fringe flags. But he found one court that had no fringe. Why? One courtroom had no fringe. All of them had fringes, but this one didn't. I'm telling you, there's meaning there, but we haven't found it yet. Yes?
I found a courtroom with a flag that doesn't have fringe, and it's in Malibu, Judge Mira's courtroom, and I argued before him that I was not my all capital letters name, yada yada. Anyway, he kind of went along with me, and I was pretty impressed by that.
Yeah, well, see, I think when you get into a real court instead of the admiralty courts, which is what I think that flag represents, but I'm not sure.
I know what it represents.
Huh?
I know what it represents.
Well, I've been told the story too. My point is that I haven't done the in-depth research to really lock that down.
Title 4, Chapter 1 and 2.
Yeah, that's on here, this disc, by the way. So we can.
Law of the flag.
Yeah. Well, I don't want to get into discussion about it. I'm just saying that these are research things that popped up as I've been through, traveled, you know. He had it first here.
Last night I was reading a book on Justinian law.
What is it? Justinian law?
And that is what we're into. I mean, that's what the courts are right now.
Well, that's your Roman civil law.
Yeah.
Yeah, and Justinian, he was a great guy. You'll love him. He would put his signs up so high they couldn't read them, and then ticket those people or, you know, arrest them for violating what the sign said. That was who Justinian was. Great guy.
Fine person.
Yes, sir.
Fine for parking.
You're right.
I forgot what I was going to say, guys.
Okay, it wasn't that important.
Oh, okay. I was one time, maybe about 6 months ago, looking at some RS information on the web.
Revised statutes.
What's that?
RS, revised statutes?
I don't know, just general language, what they're
Okay.
using. Okay. And I came across a sentence that they said, please put your name on these forms in all capital letters.
Oh, there you are.
There's something to it.
Right, there is.
I don't know what it is.
Well, we can find these things out. Now, there is a seminar that judges go to, many seminars, okay? And there are a couple of organizations that put them in. But there's one of the organizations is located, I think it's in Sacramento, but it may be Fresno. But anyway, I remember calling them up saying that I'd like to know more because it's specifically, the purpose of it is very narrow. It's specifically to educate judges. They have programs, seminars for judges. And so I called up, and the first, I think it was the second person I talked to, I said, I'd like to get some idea of what your materials are and so forth. And she said to me, she says, well, that's confidential. And I said, well, are you publicly funded? She said, yes. I said, and you're telling me that a publicly funded organization is keeping secrets from the public? And she said, well, just a minute. So then she put somebody else on the line, and this person was clearly more educated. And he did not give me that line of garbage. Instead, he said, what is it that you would like? And I said, well, I just want some information about what your organization does. And so he sent me, mailed to me, some very broadly written brochures, like advertising material, which is exactly what I wanted, because that's all I was looking for. But I just want to get an idea. That's on my list of future research, because I want to dig into that one. But I think there's a lot there that we can get through Freedom of Information Act and this type of stuff that can really expose it. And when I say expose it, I don't mean that negatively. I mean positively, because it is part of the system. And if we are aware of it, instead of having secret laws, if we know what the real rules are, it'll help us to help government obey the law.
So, Bill, there's the number one court in the land is in New York. It's called the International Court. It's in New York, and this court is a number. It's Article 3 court, and judges there fire federal judges. It's the most powerful court. They're all appointed by the President of the United States.
Get me the name of that. If you'll email that to me, I'd like to know more about it. That'll be on my list of
and they tell all about themselves and how you can use them, and it gives you all the formats.
Get that to me. I'll research it.
All right.
The International Court claims to be the only constitutional court in America.
Yeah,
well,
that's
fine.
true.
I'll research it.
And that would help you a lot.
Well,
because it gives you the, yeah.
send me the information and I'll research it.
You got it.
Because, see, but that's my aim here. I just let you know. This is where I'm headed with this stuff. So.
That seminar that the judges attend that you were just talking about, since it's publicly funded, shouldn't we be able to attend if you choose
Well,
to do
there is a little provision in both the federal Constitution and also the state Constitution that there shall be no titles of nobility. So special privilege, the prohibition against special privilege should mean I should be able to take the course. And pay for it, of course. Okay. All right. By the way, I'm going to do a footnote on this. I just recently came across this thing. This is printed out from a website. And you may be interested in this in the long run. This is not a short-run threat, but it is a long-run threat. This person, a lady, got ill, okay? And she managed to survive it, but she was very ill, and she was wondering why she got ill, tried to trace it down. And what she found out was that in Los Angeles, they have a dual water distribution system, okay? And they have what are called T-valves. And the T-valves, each T-valve individually controls the water that feeds to the household, each household. They are now, on a federally funded basis, all over the United States, replacing these valves with remote control valves. Okay, they're buried in the dirt, but they are remotely controlled, and they can determine which line of water feeds the household. Now, what's interesting about this is that what a neat way to get rid of dissenters. You know, if you make somebody ill, takes them 6 months to a year to die, you know, and they don't know, they're just feeling ill, they go to the doctor, the doctors don't know, they go on symptoms, they don't know you're being poisoned, okay, or having bacteria introduced into your water system. They can investigate it, have it turned off when they're investigating the lines and turn it on again when the investigators leave. Anyway, I got the website here if you want to look it up. It's LA, and then a period, INDY, that's the word Indy, INDY, media, MEDIA, .org / that's the little bar that leans to the right, news, that's NEWS, / 2004 / 08 / 1156 76 .php.
That's real short. Could you do the directories in between again?
Want me to repeat it now?
No. Or type it on the computer.
This is internet.
HTTP, right?
Yeah.
Still type it on the computer. In other words, pull a screen out.
Oh, you want me to type it on the computer?
Maybe notepads. Okay, shrink it.
All right.
I thought you did an excellent job of dictating it.
Well,
We shouldn't have a problem.
Well, yeah, there's always a problem.
Okay.
Okay. Okay, HTTP code. / No. Well, I screwed up. I guess I screwed up. Let's try this again. The caps should not have been on. Okay, here we go. LA.INDY. Yeah. Yeah, but I'm using Notepad, so, or something like that. Okay.
There you go.
We're getting there. Here, let's try. Almost there. Of course, maybe when we get there, you won't be able to see it. 28, 24. There we go.
Beautiful.
Okay. So anyway, that's the website address. So that's a little footnote that be aware of. I suggest that what I do is I make my own distilled water. That's it. And that, you'd be surprised how many diseases distilled water clears up, by the way. Yes, sir.
Osmosis water system. And typically a set of filters would last me a year. Water started tasting funny about 4 months after the guy was there, and I had him come out, and he pulled it out. He says, I've never seen anything so dirty. He said, this is unusual. When did you have your water thing changed? I said, about 4 months ago. He said, they're supposed to last a year.
Yeah. Well, yeah, and Costa Mesa, I noticed that when you get a very bad taste on some of these water distillers, you still get a bad taste. And I finally figured out that what you do is you boil the water first before you put it in the distiller. Apparently, whatever it is boils off. Now, they are putting something in the water in Costa Mesa, or at least they did a few years back, that they said was absolutely harmless to humans. But, of course, it was done for sterilizing and so forth of the water. But, however, they told you don't use it in your fish tanks because it'll kill your fish. Yes, sir.
Well, they have two things, regular just chlorine gas, kind of nasty to deal with, but it all escapes real fast.
Chlorine gas escapes real fast? Or chlorine?
They have two things.
Chloramine.
Chlorine gas or chloramine, which you can't get away from. It doesn't boil out or
I see.
eliminate very well.
Okay. Well, that's just let you know that we live in an interesting world, and to be informed is to be, forewarned. Right. Okay. So you all got this address, right? Yep. All right. Yes, sir.
I understand that now the money has chips in it, and that they're putting these RFID chips in almost everything.
Right.
I understand if you put it in the microwave for 10 minutes, of 10 seconds, that's the end of the chip.
Well, maybe that worked, maybe it doesn't. If the chips, if it's actually a chip with transistors and such, yeah, you can destroy it. But if it's a synchronous antenna, then it won't make any difference, unless you actually burn it out. But because, see, a synchronous antenna is basically a set of wires of different length that resonate, and when you hit certain frequencies, they'll return back a wave. So that's one type. But if it actually has a chip which takes its energy from the radiation and then uses it to re-radiate a code which is developed by the transistors that are in there, or MOS-FET or something like that, whatever they're using for the technology, then yeah, you can burn it out with a nice little soak in the radar will take care of it.
For how long?
Just an instant, that's all it takes. Just put it on power.
You might be ruining your microwave if you're not careful with it.
Yeah,
with
well, you might
basically
have to-
nothing in it.
You might have to sacrifice a bill or two to see the right
I read
amount.
one article where the bills were actually catching on fire because the metal would heat up
Sure.
so fast it would
Sure.
burn half your bill off.
All you want to do is zap the transistors in there. Okay, any other questions there? All right. Well, anyway, getting back to this, we left the subject a little bit, but okay. So you have a research guide, okay? And they have other things like the harmless error rule, okay? Contempt, error in excluding evidence. So all these things relate to a motion in limine, to limiting the error. So by the time you get through reading Matthews, you will really have upgraded your knowledge level about motions in limine and how to do in the opposition, or the opposite. If somebody comes up with a motion in limine against you, how to argue against it. Okay? They have other things too, writ of mandate, writ of prohibition, power of court to amend and control. So I'm just showing you that the resources here. Now you have a procedural checklist. Here's things you need to watch out for when you do a motion in limine. And it gives you the scope. This checklist sets forth the procedure to be followed in obtaining an order in limine without making a noticed motion. Well, there you go. How do you do it without giving them notice? That's interesting. Okay, for the procedure on noticed motions generally, see Chapter 372. And you say identify the facts that are inadmissible in evidence. Consider the facts opposing counsel may refer. Consider whether the motion should address facts even where opposing counsel has not indicated any knowledge. Determine if there's other factual evidence. Determine when and how to raise the issue. Okay, and they refer you to paragraphs where you can read more on this, see? Pretty neat book, isn't it? Make enough copies. Stating the grounds, memorandum of points and authorities, proposed order in limine. See, show you how to put it together. Present the motion orally or give copies of papers to court and counsel at trial, preferably before jury selection. This should be done on the record in chambers with all counsel present. If not familiar with local procedure, check with court clerk before trial to determine procedure for presentation and service of order in limine. Look at that. They always tell you they can't advise you on the law, right? And here they're telling you here, check with the clerk. Again, check with their requirements. Okay?
So if the clerk argues with you, take that little sentence there, take that down there and show it to him, right?
Yeah, if the clerk argues with you, you're saying show him this, but no, I have a better approach. Ask the clerk what the requirements are.
Yeah, right.
That's
what you
arguing
said.
with you.
Yeah, right.
Okay? Now, finally, we get to part 5, the forms. How to do a motion in limine. Well, you have the basic captions, Superior Court of California. Notice they don't show you the whole thing, but they just make suggestions. Okay, here's the name, the number. Now, you notice this kind of wrapped, all right, because the case number would be to the right, the motion in limine. Okay, you have these little, like right up here, you have this little parenthesis. Well, that's supposed to be the parenthesis down the middle, okay, that divides the left and right sides of the paper. And so you put the date, time, and department of where it meets. You have the name, you have the trial date, defendant, these are suggestions. And now they give you the actual text to write in. Put in the moving party's name, and hereby moves this court for an order, and then it tells you, specify, instructing defendant and his court of counsel not to refer to interrogate any witness concerning, comment on, or so and so and so on. See, so I give you all these suggestions. This motion is made on the grounds that, and you specify the fact the plaintiff received compensation for his or her medical expenses from a collateral source is irrelevant, and any attempt to convey this information to the jury would be highly improper and prejudicial, and so on. So they just give us examples, and then you sign it. Okay? And the form of motion in limine above should be presented to the judge with copies to all counsel when making a motion in limine on the record. How do you present it to the judge? Anybody know how to do that? Well, if you're standing in the court at the time, you just hand it to them, okay? But basically what that means is you file it. That's how you present it to the judge. You file it. Okay? It goes in the court record because every judge, before he goes into the open court, reviews the record. See, the timing, here's a general rule of thumb on timing. This is just general because you have to check your rules on different kinds of motions as to what the real timing requirements are. But as a general rule, you set up the hearing date 30 days after they're served. okay? If you think it'll take you 3 weeks to find your person, then you set it up 30 days plus 3 weeks. But whatever it is, you get a date set. From the moment of service, they have 20 days to answer your motion. You have 5 days to reply to their answer. That makes a total of 25 days. And then the judge has 5 days to read the whole thing over. You serve, get the answer, get the reply to the answer, and the judge gets it. That's how it works. So he needs those 5 days to review it. So they review those cases. Now, I acknowledge they don't read your papers, okay? That happens a lot. What they do is they assign it to research assistants. Research assistants summarize it, pick out the basic issues, and let the judge know what that is. And these research assistants are all attorneys, or they're going to school as learning to be attorneys, but they're qualified to analyze the cases. But they don't have the understanding that the judge does, and sometimes they miss points you're trying to make. But anyway, that's the realities of dealing with the court system. Anyway, so this gives you kind of the form. This is how you make a motion, okay? So then for discussion of the matters to which the motion may be addressed, see sections 373.12 in the Matthew books, of course, Matthew Bender. All right? Local counsel of court or local court practice may require service of a written motion with a certain number of days prior to trial. Counsel, yeah, and there's another thing. There's a certain point where they cut off all motions because the trial's coming. No more motions can be made. So that's all in your court rules. I don't know what the specifics are, but be alerted that you got to watch these. Yes, sir.
What about ex parte motion? Can that be done like 24 hours beforehand or no?
Well, I wouldn't say 24 hours because the judge has to have time to read it. He needs at least 5 days. Okay? Okay, now, here is another order in limine. Okay? Another suggested form, I think. Wait a minute. Oh, this is an order in limine. So this is a sample order. So you can go to this form, type up your proposed order. Okay? Fill in the blanks. Yeah, you put it in the proper form that I showed you on those others. But the important thing is they give you the wording. The language, right. And these are from winning cases. Okay? Somebody won a case using this, and then they took it and generalized it. All right? Let's see what else we got. Well, that's all they... And then they talk about the use of the form. The form of order above is for submission to the trial judge with copies to all counsel along with the motion in limine and memorandum of points and authorities. Counsel should check with the individual judge's clerk to determine whether a written order is appropriate and the procedure for filing and serving any signed order. See? Another thing on your checklist. Now, this Matthew Bender is not the do-all and be-all of court procedure, but boy, it sure gives you some education. That's why I like it so much.
Bill, I notice he uses Deering's. Do you have any preference in West?
Yeah. When you're looking up the California codes, there are two major sets of books. One of them is called Deering's, because that's the publisher, and the other is West's. All right? I prefer West's. The reason is because I found typographical errors quite often in Deering's. Mm-hmm. So I quit using Deering's for that reason. It's good to look in both because, you see, these books that they have are annotated, and they don't all refer to the same cases. You see things in one that you don't see in the other. So the cases law is good, but for actual quoting, I quote from West's. Also, yeah, okay, you had a comment.
Yeah, why would you? Why do they have, one Deering's and one West? Why is there two? Why isn't there just one?
Well, it's called competition in America. Two different publishers. They are the survivors from however many there were in the past.
Seems like it would just make things confusing.
Well, that's one of. If you want a dictatorship, we can get consistency.
No.
It's supposed to be confusing.
That's right. This is one of the disadvantages of freedom. Okay? Buyer beware. But if you can find an experienced voice to tell you what the difference is, and that's been my experience, I've looked up laws and I said, wait a minute, you know, and I look at the other and wait a minute, you know, there's something wrong here. Well, it turns out that West was the right one. So, and it happened to me enough times I said, I better reconsider Deering's. I was using Deering's because I had the actual book at home. You know, I had bought a used set. But then when I started finding this out, I said, well, I'm going back to West. They are quality when they come to quoting.
Bill, I have a question about statute of limitations. For one thing, it's called the statute of limitations.
Yeah, in common law, there are no statutes. It's dead.
Okay, so if I've got a case that I'm dealing with that's actually some parts are past the statute of limitations, I can get it in a common law and proceed with it?
Yep, there's no statute of limitations in common law courts because there's no statutes.
That's good.
Yeah, that's an interesting thing, you know. The beauty of common law, what I like about common law is that it deals with reality, okay? You can get entangled. You can't get back to it. Common law serves the interests of the people. Statutory law serves the special interests of the pressure groups, whoever they may be. Okay? Corporations typically. Yeah. So I like common law, but I also like statutory law. As a general rule, it's reasonable. But, you know, where it fails is in the discretion. Okay, well, that was Matthew Benders on motions in limine. It still goes back. You notice they gave you this little form, but you still have, as they point out, they still have points and authorities. You still have affidavits. You still have notices, you know, that sort of thing. The principles are there. Do you feel like now you understand a little bit about how motions work and how you can use it to ask for anything from the court? Absolutely anything. Now, a little bit, right. Now, a question came up earlier about this idea of, well, how do you find this information? And I want to reiterate the answer here. When you go to you have a problem, and in your heart, your instincts tell you something's wrong, and you want to fix it, whatever it is. The first thing you got to do is define your own problem. If nothing else, sit down and try to write your problem on paper and give it to a teenager and see if he can understand what you wrote. Of course, I realize that's risky. But right, they can't read. But nevertheless, the idea is to define your problem. And then you go, like on the Internet. The Internet's wonderful. We have this outfit called Find the Law. And they have cases going back to 1934. Okay? And you look up, just put keywords in and see what cases pop up. I do that a lot. That's how I find a lot of cases that way. Yeah, and you just use your talents, you know, to pick words. But it really, really is a seek and ye shall find situation. And because there is no magic way to research. It's kind of using your talents, your instincts, picking the right words to search on. That's one way, is to go to Find Law, and it's an excellent way. Another way is to go to the jurisprudence books. There's one called American Jurisprudence, and they have a first, second, and third set, I think. I don't know if they're up to the fourth set yet. There's California Jurisprudence. Okay, so they're AmJur and CalJur. And California Jurisprudence, and that's what it says, CALJUR on the spine of the book. You look up CalJur, and you look up keywords in there. They have an index, so if you don't see a heading that way, you can go to the index and they'll refer you to things. And you start looking at the little case notes. They're little short, they're about an inch long, a lot of them, maybe 2 inches at most. And they give little descriptions of what the issue was and how it was decided. And these are wonderful things, and they have them categorized. So, and they'll give you several cases with 1 point. So you go through these jurisprudence books, and you can find cases. Amazing what you find that relates to what you're looking for. Another source is, of course, Matthew Bender. I mentioned that already. Another source, there's an outfit called Witkin, or the book called Witkin, and it has a lot of procedure stuff in it. You can look there. Witkin, W-I-T-K-I-N. Okay? Witkin. Yes, sir.
It's Witkin.com.
Oh.
They're in San Francisco.
Okay. Great. Well, their books are on every law library shelves. But do they have access to the data at Witkin.com?
They sell the books a lot of money.
Oh, yeah, they're expensive books, but, you know, you can read them for free at the law library. And you can copy them, you know. So there's other resources, and one of your greatest resources, believe it or not, is the law librarian. You go there and you say, here's the problem I want to get information on, and amazing how they'll guide you. This.
In Witkin, if you call them, they will say, what's your name and number, and they hang up, and they get back, they check you, and then you ask for negotiable instruments, they deny they have it.
Right.
Then they come back again, they cover up. It's impossible to get in even with the website. It's covered
Well,
up.
well, you do have state and corporate policies, and sure, they realize that people can take this information and beat them over the head with it. So, obviously, they're showing resistance there. If you're an attorney, you're a little more trusted. One of the things that I found that was interesting, now I took the trouble to become a notary public, okay? And I'm thinking of, I got to do some homework here because I'm really fresh at it. I only had it a few months now, and I haven't had time to research it. But I understand that a notary can make a demand for payment or can refuse a payment or refuse a demand for payment. There's a number of functions in there. And I understand there's a guy around who has made a career out of this thing with being a notary public and being quite successful. So I'm going to check this out. But one of the little side benefits is that because the FBI has checked me out, you know, notary public gets it, they do a background check through the FBI. Well, that makes me a trusted liar. I mean, person. And I can go down, if I need a paper signed, I go right down to the jail, I identify myself as a notary, I stamp with my notary stamp onto the little form you fill out, the visitor's form. They go right in, and I get the signature. Now, I don't abuse the privilege. I mean, you know, it's for conducting business. But I have business to conduct, and they don't interfere with that. They say, you're legit. We know you're okay because you went through a police check. See? So they just, now I'm part of their team. You know, I'm part of the functioning of the state of California.
Also an officer of the court.
And in a sense, yeah, I could be an officer of the court, I suppose, yeah. But the idea is, well, it depends on your role. You know, just you're not an officer of the court until you're in the court functioning. Yes.
Is a notary public and competent fact witness when it comes to, let's say?
Well, the thing is it takes two witnesses under common law, whereas the state will accept one witness if he's a notary. But a notary has limited witness authority because all he witnesses is that the person is who he's, you know, he witnesses the signature, or he witnesses that he takes an oath by somebody saying that, yeah, such and such is true, and so he can do that. And he can also certify powers of attorney, copies of it.
Well, yeah, but you can also do notary presentment. Let's say if a
you can do presentment, right? You can do denials,
for the
right?
Acceptance or,
yeah.
or
so there are
dishonor.
limited functions, but that's not being an officer of court. That's doing a function, a state function.
Right.
But you're in the executive branch on that one. See. So, but if you're actually in court doing some court function, well, yeah, then you're an officer. Well, you got to remember don't get enthralled by the idea of what an officer of the court is, because one of the officers of the court back in the old days was called the court jester. Okay, he was an officer of the court, and his responsibility was entertainment. I've been thinking of hiring one for my court.
I know a lady who had some criminal charges as a teenager, And it took her a little over a year to get her notary, but she did get it.
Oh, yeah, yeah. I mean, you know, getting arrested doesn't necessarily, or you know, getting charges. What they want to know is, are you trustworthy? That's what it boils down to, you know. If you have a record of moral turpitude, yeah, they don't want you. But, you know, if you just, they're not going to get mad at you for having traffic tickets, or maybe you stole something when you were a teenager. You know, they're pretty forgiving along a lot of those lines. Yes.
Is there such a thing as a common law notary?
I don't know. I guess. Yeah. I guess. Yeah. Notary is an ancient position.
I know of two people that have common law notary stamps.
Yeah. Well, I've got to check it out. You know.
They had to go all the way back.
Yeah. But I'm going to check it out. But you have to understand that if you're in the legal stuff, there's nothing better than being a sovereign. Okay. Well, let's see. It's, gee, we were supposed to start eating at 5. And it's 5:30. We're late. You want to quit till 6:30?
Sure. Yes.
All right.
That time goes by fast when you're having fun.
Yeah, it is. And when we come back, what we'll take up on is the general motions and orders. Okay, 33-372.
Go? I guess that's what that meant. Anyway, I was down here this morning. I was trying to encourage you people to pay kind of a special attention to Thornton. He has kind of a different style of message. If we get our common law back. Oh, by the way, I'm Rotten Ron for those of you that don't know. Oh, yeah. I fired everybody on the public payroll.
Good for you.
And when I got to prison, the guy said, "Man, you're rotten." So they started calling me Rotten Ron. I said, "Well, I think I like that." So it's kind of stuck with me. Well, anyway, on this message that Bill's teaching, if we ever get our common law back, which is what he has kind of a different attitude, it's never gone anywhere. But if we that are out here struggling to find America get it back, you're looking at Resurrection Day today. I mean, we currently have a lot of people doing time, right? Mental institutions and prisons. Never an injured party. We have instances where there's not even trials going on. So this message that Bill's teaching, he's been trying to make me understand it for 20 years. I'm starting to catch on. I hope it don't take you that long. I hope the efforts that we're putting out right now are going to be encouraging for the rest of you, because in a few months we ought to have a very interesting story to tell. Trying to get one party that's currently being held in a mental institution, Soviet Union style, no trial, not one word of testimony, and 3 years. Just do 3 years in the mental institution, and then when you get out, the phony charges that we've got against you, why, we'll bring them to light. And probably the long and short of it is, before they're done with the prison and all of that nonsense, they'll probably be deporting this lady. Well, anyway, the common law has become extremely important to me at this point in time in my life. And if it's successful, you will never probably need any other style of, well, I don't want to say that, because I would imagine when this lady's out, we're going to be somewhere in a Title 42 or a RICO action on 28 people that have tried to ruin someone's life. So you've all been there, and you've all heard all of the speakers and all of the wonderful things. All these years I've been telling people, you read about a case where the Supreme Court says you guys can't do that. You turn around and try and do that, and it don't work for you. You know, there's only one thing that nobody's ever done. And that's gone back and investigated the structure of the individual. Who was he? What clubs did he belong to? Had he done his UCC? Was he in control of his straw man? Who knows? Did they just throw out a tidbit to drag us in? Well, this message that Bill is teaching is going to teach a lot of government people a lesson that they can bow out if they want. But I'm sure they'll opt not to. But there's just too much of this going on, too many people. I've been at it for I started in October of 1973. I was actually upset a lot sooner than that, but it took me a while to find that there was other people that cared. In September of 1973, I probably had more guns and ammunition than the whole gang here put together. And on my vacation, I just started shooting off my ammo. And my kids said, well, Dad, do you want us to pick up the brass? Because I used to have it reloaded all the time. I said, hell no, forget about it. I ain't going to win this thing by myself, and nobody gives a crap. The next month, I ran into the Orange County people. I got involved with an outfit called Tax Action Council back in 1973. And boy, I'll tell you what a trip I've been on ever since. Well, I'll tell you though, I've been looking for America, can't find it. If it's ever going to be resurrected, Bill's got the only message that's going to do it. Now maybe after, and we know that there are somewhere in this country judges that will chastise unruly servants. It's a damn shame. It all has to be done right. But it's just like the poor lady that's in right now. I don't care how stupid you are. If they don't have jurisdiction, ignorance is not going to be their excuse to move ahead. So we should be able to help other people as this process continues and continues to develop. So listen up very carefully to Bill, my dear friend.
Well, it's too late. They've already had a chance to ignore me.
Well, are you telling him anything worth a damn, Bill? I mean, it took him a long time to get it pounded into my head what he was doing. So I hope it don't take that long with you people. And it looks like he's got a lot better tools than when he used to work with me. Okay, Bill, it's all yours.
Thank you.
It's all yours, Peachy. How the hell? There you go.
Thank you. Appreciate that, Ron. Ron doesn't. Ron's kind of a. Yeah, Rotten Ron is a kind of a hidden entity here. He's kind of a hidden entity here. Tell you a little bit about Ron. He got arrested one time, something to do with income taxes, I recall, and spent a year in the Gray Bar Hotel. I think it was a year, wasn't it? 1 year?
Well, they gave me a year.
Yeah.
Even that was interesting. The judge says, I sentenced you to 1 year. And I said, well, I want a year and a day because I talked to guys that were already in prison. If you get a year, that's not even considered a sentence. Right. You get a year and a day, you get furloughs and weekends and stuff like that. I said, give me a year and a day. He gave me a year and a day. I got 2 furloughs while I was there for a week.
Yeah. But then when they put him on probation, he said, screw you. He didn't want probation. So I had to force him out the door. And he told him, he says, you tell me where to be on what day and I'll be there. Otherwise, I'm not going to screw you guys. Okay? So all you did is you put me in jail because the crime I committed was that I worked for a living. Okay? I mean, he pulled no punches with this judge. He says, yeah, and so then when he gets out of jail, he wouldn't talk to the probation officer. He didn't want anything to do with him, and he told him in advance he wasn't going to. Okay, so this guy they couldn't do anything with. he went to where he'd say on the certain day, whatever it was, and they never showed up, okay? But Ron has quite a history of, quote, commitment behind him. He got committed, which proved his commitment to them, and they decided they didn't want to mess with him anymore. And so,
By the way, I wasn't in a common law court or a nisi prius court, or what was it, nisi prius?
I don't know, it's an unknown court, whatever it was, the tax court or something, I don't know, whatever it was, but they got you. And then, and of course, while he's in there, he's doing what all of you should do when you go in, and that's educate the other prisoners. You know, it's an opportunity to administer to other people. That's exactly right. And then you give them ideas, and they go into court, and they raise hell, and they're still in jail, but they're raising hell, you know. And there was this, it's kind of funny. And you know, over in the Philippines, the Japanese took over the Philippines for a while, and they had this deal where apparently some of the Filipinos were not happy about being taken over, and so they'd go out and they'd stir up trouble with the Japanese. Well, the Japanese decided, well, the thing to do is to kill them, which they did, okay? But the problem was is that every time they killed one of these Filipinos, he knew 2 or 3 people that were sort of, you know, upset, but neutral, and then that pissed them off, you know, and the next thing you know, they were out there stirred up trouble. Every time they killed one guy, they created 3, and the problem just grew and grew and grew, and too many Japanese were getting killed, and they had to back out, you know. They couldn't, and here's what we have. Look at all you sitting there, all right, and myself included. Why are we where we are? Because we have friends who got hurt out of this deal, right? So every time they hurt one, they don't seem to understand. It's interesting. Government understands one thing. If you got a problem, you beat somebody up to solve it, okay? And so when they beat somebody up, they create more. Now, I remember back in well, let's say, I don't know, maybe 15 years ago, something like that, 20 years ago, the feds figured out that there were something like 1,000 dyed-in-the-wool, absolute, no holds barred, people who would not pay the taxes under any circumstances would go to jail, okay? This was what their own research showed them. Of course, that means there's a lot of people who are less committed. So 5 years later, they did another survey. They found there were 5,000 people out there that wouldn't. That's what their own research showed them. They didn't catch on. They don't understand what the problem is. And also, another time, I got an email from this researcher who worked for one of these think tanks. And she was concerned about the militias. That was her job, to analyze and so forth. And she was commenting that try as they might, they couldn't find where the centralized, where this was coming from. Here these people all over the country are forming these militias, they're doing these things, and they just know that there is some central source that's influencing all these people to come up against the government, okay? So I wrote a letter back to her, and I said, the reason you can't find these people is because, you know, the central source, they don't exist, okay? I said, what you're observing is that there is a central source of abuse of the people called Washington, D.C., and what's happening is that you're seeing a general reaction rising up against the abuses of this centralized source of misbehavior. She wrote a letter back to me thanking me for this. You know, she says, I never thought of that, and I'm going to look into that further. You know, in all her research and so forth, it never occurred to them, this concept. Well, I've never heard from her again, but it was interesting that here they were in the think tank. They had never occurred to them, maybe it's us. You know, we're the...
It never occurred to them that the people in Iraq are trying to defend their country against an invasion.
Oh, no, those are terrorists and insurgents.
Yes, that's right. You get with the program. Bush is not going to approve of you.
Wasn't it Shakespeare that said, a rose by any other name
Yeah.
would not smell as sweet?
Well, I hadn't heard that version, but okay. Anyhow, Ron has some credits. For several years, he paid the rent out of his own pocket. He had a couple of somewhat helpful partners, but for several years, he sponsored a meeting place, actually rented office space, had copy machines for people who were running their cases and everything. He's been quite an asset to people like us. And so he's got a remarkable record of supporting, putting his money where his mouth is. So that's why when Ron felt like he wanted to contribute a few words to this thing, I said, sure, great, because Ron is really has a history of being a good guy. So there you are. Thank you, Ron. Yeah.
Don't let that get out.
Don't let that get out, he says. All right. Yeah, I know. I'm ruining his reputation right now. But hey, you know. But you know, let's look. I want to reiterate why are we doing what we're doing, and I feel that that what is on those name tags is our real. That should be our theme right there. We're here to encourage, because we can't guarantee it, but we're here to encourage the government to obey the law. If they would obey the law as intended by the Constitution, as intended by many other sources and philosophies and so on, this place would be a lot better. And so I'm not, look, I'm one of the owners of the system. I'm one of the people. And everybody else who claims he's a people is one of the owners of the system. And I'm not against the system. I'm quite the opposite. I want the system to work. Yes, I recognize there are certain controls. I mean, you know that you've met people yourself who you give them half a chance and they'll take advantage of you, cheat you, or whatever. And yet if you have reasonable controls, they tend to stay more or less in line. And so I recognize we have some need for control, but there's a big difference between setting up a system of common rules that everybody can appreciate and understand. There's a difference between that and using the rules to attack your political enemies or to somehow create a new prison industry or various things like that, see? So if we have real, genuine obeying of the law, we will have real, genuine freedom, okay? So that's my position. I'm not in rebellion. I'm not, you know, there was a meeting very similar to this one in Las Vegas about a month ago. Now, if you speak English and you really understand English words, you're going to be startled by this. During the meeting, it was people who were interested in, you know, protecting their rights and this sort of thing. One of the leaders of the meeting got up and he said, how many of you are insurrectionists? And about half of them said, yay! You know what an insurrectionist is? Any idea? An insurrectionist is somebody who believes in rebellion by force. Let's get our guns and so forth. That's what they believe. Okay? Now, I'll tell you, you don't want to be an insurrectionist. That's not our purpose. I own the system. I don't want people rebelling against me. I want that system to work. It's a good system, but it's being abused. And it appears like that there's enough organization with black budgets and this sort of thing. I know you're all familiar with black budgets, right? No? Black budgets, that's money that Congress awarded that does not have to be accounted for. Okay? Black budget runs into multi-millions or billions of dollars. So it's black budget companies or organizations, when they set up telephone lines, they have what they call hello lines. Okay? That means when somebody calls the number, they answer hello. If you don't know why you're calling that number, you're not going to get anywhere on those lines. You can never find out who owns the line or anything like that. By the way, I have an article about that on that CD or on my website. It's there. Article in Scientific American. You're familiar with that publication, right? Scientific American had an article a few years back, which I've repeated on the website and on the CD, where it's officially okay for the government to lie. Okay? Officially okay for the government to lie. Okay? On these black budget programs. All right? So there's a problem there because secrecy always leads to abuse. again, I'm not against the government. I'm against the abuse. Okay, and when I encourage the government to obey the law, I'm going to do it through the courts, and that should be our theme. If you adopt an attitude like that, it's going to be very, very difficult for the government to come against you, because what can be more obvious than obeying the law? Advocating obeying the law. How can they, it's a lot of times it's not so much important what you say as it is how you say it. Okay? So you got to get the right terms. Well, I have the terms of peace. Okay? The terms of law, order. Hey, there's a good theme, law and order, right? It's a popular theme. Hey, we ought to pick up on that. That's what we want, law and order. But what kind of order? We don't mean the kind of order where agent provocateurs go in and beat up people to start a fight so that now they can arrest them. That's kind of considered unfair. And so anyway.
They were doing that since the 60s.
Oh, yeah, that's their theme. They found out it's a formula that works. But until we become aware of it. All right, I want to mention a couple of things. We had some conversation on the side during the break. And I'd just like to bring this to your attention. This is not part of our original deal, but it's important enough for you to realize, because some of you people are in the midst of the battle, okay? And there's a couple things you need to watch out for. One of them is a demurrer. Anybody know what a demurrer is?
Yes.
What is it?
I mean, so what?
No, not at all. Not at all.
What's your authority?
It's an
Demurrer.
agreement with the facts.
That's closer. That's better. The demurrer, basically, when you get sued and you answer that lawsuit with a defensive kind of answer, okay, in your defensive answer, you will answer on a number of grounds. One of them is they have the facts wrong, so you challenge the facts. They can have the law wrong, so you challenge the law. And so then you basically go to trial. Okay? Now, in common law, there's a hierarchy of papers. You first have the action that takes place, the original lawsuit. Then you have the answer. Then you have the reply to the answer. And then you have the reply to the reply. And then the terms get technical. I can't remember what it's called. But it goes back and forth. And each time that a response comes through, the response must be limited to whatever the issues were before and less, because you're supposed to narrow down these issues. You can't go outside. So you have the initial lawsuit, you got your initial wide open response. After those first two, the reply to the answer must stay within the issues raised in the answer. And then, yeah, you got to stay on point. And then the response to that reply has to deal with what's on that reply. So it automatically comes down to there. At some point, you're ready to go to trial, okay? And somebody remember what that's called when you're ready to go? I keep forgetting the name of that paper that you file that says you're ready, that the issues are ready for adjudication. Nobody remembers it? No, that's a conference. I'm talking about a paper you file. What's this paper you file that says you're ready? Anyway, there is one, okay? There's a judicial counsel form you fill out. Huh? No, it's just a single sheet of paper says you're ready.
It's like a request for.
Well, no, it's just you're ready. There's no more issues to be discussed. It's a single sheet of paper. It's just, yeah, an at-issue memorandum. That's what it's called. Right. An at-issue, 2 words, at-issue memorandum. That's the one. So when one of you is ready, you're not going to answer anymore, you're at issue. That means you're ready to be adjudicated, all right? Now, that's the common law procedure. In the equity procedure, they limit it to 3 papers. Accusation, answer, reply to the answer, okay? It's in common law where you have this longer list, all right? Now, whether you're talking about equity or you're talking about common law, either way, there is a maneuver, a paper you can file called a demurrer. Now, so at some point, you're going back and forth, and then somebody puts in a demurrer. The demurrer is a challenge based only on law. When you file a demurrer, or when the other side files a demurrer, whoever files a demurrer is stating in his demurrer, whether he states it openly or not, makes no difference. He's saying, I got an issue about law, but I agree to all the facts. So don't file a demurrer if you haven't something about facts that you don't like, okay? If they've made up bad facts. Right. So you must always remember a demurrer is automatic agreement to all the facts. Okay? Now this is great. Yes, sir.
Can you reserve issues of fact that you're questioning?
No, if you have a reservation of issues, then file an answer, a response, or something, and attack it.
So you have to deal with. You cannot combine the two. You have to get rid of all.
Yeah, you do combine the two in an answer. But if you're just doing a demurrer, you've cut out half of it. You've said, well, the facts are okay. I'm just talking about law. If you want to talk about both law and facts, then continue responding to the paperwork.
That's similar to going for a summary judgment. You now want accept.
Well, okay.
I'm jumping ahead. Never mind.
Summary judgment does not exist at common law except in one place, and that's where there's a contempt of court. There is no summary judgment otherwise. Yes, sir.
Yeah, I'd heard somewhere that if they come back with a response of failure to state a claim without, on which relief can be granted.
Well, they can make a motion, sure.
Yeah, but when they do that, they have stipulated to the facts.
Well, it's like, I guess it's a demurrer, yeah.
Yeah, okay.
It's a demurrer in disguise, yes.
In small claims court, I won a case by using the word demurrer.
Okay, you want to, yeah, well, I didn't say you can't win. I just said you're agreeing to the facts.
Well, what I did, well, not exactly. When I...
You got the microphone here?
I was the...
Here it is. Microphone coming up. All right, now wait a minute, start at the beginning. You were in small claims.
In small claims court, I won a case by using the word demurrer. I was the plaintiff. There was a defendant. Defendant starts testifying that the contract said this and that. And I objected, and the judge said, based on demurrer, and he says, the judge said, you sure use large words. Are you an attorney? I says, Your Honor, where are the facts? So he turned around to this person and asked, where is the contract? Well, there was no contract. She was saying there was.
Well, then that was not a demurrer.
Well, it probably wasn't, but it worked, and she blew it, and I won the case.
Well, you got to remember that in form you were incorrect, but in substance you were correct.
Yeah.
So that's what he looked at, was the substance.
Right.
Remember that substance trumps form. And so even if you called it a demurrer, just based on what you told me, you were still dealing with facts. You said the facts were incorrect. Right. So, it's the same thing in your paperwork. Your paperwork, you have all these titles and so forth. You can misname it, but what does the body say? And so you attack the facts even though you called it a demurrer.
That's right.
And when you asked you if you were an attorney and you said no and you were talking about this other stuff.
No. I didn't answer.
Well, the thing is that it was obvious you weren't, because an attorney wouldn't have made that mistake.
No, I just got rid of that and said, Your Honor, where are the facts?
That's it. That was the substance. That was a substantive claim. Well, see, the thing is, though, is you agree to facts. Now, here's what happens. A lot of times, you file something, and the attorneys come back with a demurrer. All right? So, here's what I do. I come back, my response to the demurrer is that I agree, yes, he's right, yes, he's right, yes, he's right. So delete all those from my claim. What's left is just the facts that he agreed to and this law that he missed. And now I move for summary judgment based on that. And he automatically loses because he agreed to all the facts. Okay? I take out all the conflicting things as long as I have enough left to hang him on. Okay? It's a great technique. Now, let me explain summary judgment. summary judgment, it's another motion, okay? You know about motions. All right, summary judgment is a motion. Basically, what you're doing is you're saying, Your Honor, if you're in a regular equity court, you say, we all agree on the facts. There's no disputing of the facts. The only question is applying the law to the facts. That's what a summary judgment is. Okay? Summary judgment does not exist in common law, except in the case of contempt of court right in front of the court. If it happens right before the court, you know, like somebody insults the judge or something like that, that happens, then there's summary judgment, because the court has all the facts. See, summary judgment is nothing more than applying to the law to facts that everybody agrees on. If there's any dispute of the facts, you cannot have a summary judgment. Okay? So everybody agrees on these facts, they apply the law. All right, so summary judgment occurs in equity proceedings. However, in common law, you can't have a summary judgment. But you have something that's very close to a summary judgment. What you do, you have the accuser, you have the answer, you have the reply to the answer, you have the response to the reply. And so it goes narrow downing. At some point, somebody does either a demur or, what's that form again? I never can remember. Ad issue memorandum, okay? If it's an ad issue memorandum, the next step is obvious. You go to trial. But if it's a demur, the demurrer says, I agree to all those facts, and now we just apply to the law and all the paperwork that filed before. It's like a series of motions in a sense. Okay? Now, when you get to the end of that, either demurrer or ad issue memorandum, either way, the next step is the judgment. No trial. Okay? No trial. Just the judgment when you're at law. At law is very efficient. All right? You don't need a trial. Why? The reason is because the trial was held already. It's on paper.
Facts are agreed to.
Pardon?
Facts are agreed to.
Or even where there's a dispute. It's all on paper. You were having the trial when you filed your paperwork, going back and forth, your arguments. That was the trial, okay, when you're at law. And so the only thing left is judgment, okay? And if they do an ad issue memorandum or if they do a demur, that's what you do, the judgment, okay? Yes? There's more.
I wanted to ask you about a slap motion.
Let's get it closer.
I wanted to ask you about a slap motion.
Oh, a slide motion?
No, it's called a slap motion.
Oh, slap motion. Yeah, trying to...
The first attorney on this particular thing that I'm being attacked on filed a slap motion.
Do a counterclaim.
And a demur. And the judge got really pissed off because it's supposed to be filed against corporations, not in reference to a person.
Right, because persons have rights and corporations don't.
Right. And so the judge, because of the motion... Okay.
Stop. Time out for tape change.
The judge, because he said that the attorney filed the wrong motion, slapped me with a sanction of $5,000.
Well, then what you have to do is you basically have to, are you the plaintiff?
No, I'm the defendant.
Oh, you should have done a counterclaim, make yourself the plaintiff, challenge jurisdiction, and now you're in charge.
Okay. Well, I need to do that now.
Well, it's a good time, I guess. Not to be sarcastic or anything, but yeah, you've got to be on top of it. You got to respond. And yes, that calls for a counterclaim. And the issue is jurisdiction, and it's your court. Okay, that's the key. You got to make it your court. You're the sovereign of the court. And then if they do anything, see, that judge is only a judge in their court. But once you challenge jurisdiction, everything's supposed to stop, and the burden of proof is on them to prove their jurisdiction, to prove that they suffered an injury, okay? And you're sitting in judgment deciding whether or not they have jurisdiction. Now, again, don't take that lightly. I mean, put on a good show. Make sure, I've told you all about that.
I try to do that from day one. It's like, okay,
No,
so you're
trying doesn't
claiming
work.
this, that,
Let
and
me
the
tell you
other.
something.
What are the damages?
Look, do you have a pencil in front of you? All right, set it on the table. Okay, you got it on the table? All right, now I want you to demonstrate to all of us how you, quote, try to pick up the pencil. Don't pick it up, just try to. I want to see a demonstration of trying. I want you to try. I want you to show me how you try to pick up a pencil.
How I try?
Okay. Yeah, I don't want you to actually pick it up. Just try to pick it up,
try.
okay? No. All right, I'll see you. Sure. Yep, see you then. You see, trying is a phony word, in my opinion. Okay? You either do it or you don't. These guys are going to mess with you, and you've got to mess back. And the best way to do it is with a counterclaim based on jurisdiction, because there's plenty of case law. You just do a little research, you'll find it. There's plenty of case law that says once jurisdiction is raised, challenged, they must prove their jurisdiction before they can take another step forward.
Prove it on the record.
Should you also try to move to a superior court if it's an immunity court for a criminal?
Pardon?
If you have a criminal suit by a city against you and you do the counterclaim, should you also try to move it from uni court to federal court or to federal
I think you
or
could
superior?
if your counterclaim's more than $25,000 or whatever their limits are, then they lose jurisdiction. They have to transfer it.
But this is criminal, not civil.
I know, but you've connected the two cases, see? It's a counterclaim. Now, the problem you run into is that you're going to try and file a counterclaim, and they're going to say, oh, well, you have to go down to civil and file it. But they're actually wrong. But nevertheless, the ignorance is so pervasive through there, it might be just as well you go down to civil. You still call it in your body. You still make it a counterclaim, and then you start, making motions or orders, issuing orders out of your court to the other court. Or what you can do, here's another trick, is you can move for a consolidation of cases. Okay? Because why? You have similar parties, you have similar issues. So it calls, if you look up the criteria for consolidation of cases, you'll see that justifies the consolidation.
Well, I just put in a claim to the city for what they've been doing up until now with violations, which I plan to sue for in federal court, so should I do the consolidation there then?
No, consolidation means you've got several cases and you bring them together into a master case, which is your case, of course. Your court. You'll sit in adjudication of all the cases. Okay. Now, I have another thing I wanted to bring up, and that is vindictive prosecution. I had note paper or something here. Okay. Whenever you have a city that has some sort of errant personnel in it, where they're using the system in order to carry out some sort of vendetta, which has been known to happen. When you raise the issue of vindictive prosecution, there we go. Shift positions here. Whenever you raise the issue of vindictive prosecution, the burden of proof automatically shifts to them. Okay? They have to prove, not just claim. They have to prove that they're not being vindictive. And that proof, it has to be, because after all, you're making a counterclaim, right? You raise that issue of vindictive prosecution as well as jurisdiction. They have to make the proof, and guess who sits in judgment? Right. So, now remember, one of your key arguments is that the people do not yield their sovereignty to the agencies which serve them. All right? Now, I want to point out, which I've done many times before, I guess. All right, we have here we have an example, okay? And on this example, we have this case Now, this case is the one in which we found the judge in contempt of court and fined him $1. Okay? And $1. Yeah, he couldn't pay it. I guess he was poor. And but we found him in contempt of court. Now, understand that the purpose of contempt of court is twofold. Huh? I suppose so. But the thing is, there's two purposes of contempt. The first one is to preserve the dignity of the court. The other is to preserve the authority of the court, like enforcing court orders and that sort of stuff. Well, when we found him in contempt of court because he was challenging our authority, the presiding judge removed him from our case and 900 other cases and assigned him to Timbuktu, somewhere else in the county, handling only criminal. He no longer could handle civil. So he never paid the.
You need to stand here.
Okay.
Too much brightness.
All right. We need to. He didn't pay that fine, but then you see, when he was removed from the scene, it was no longer necessary to enforce the fine, because after all, he was no longer in contempt. See, that's why we never pushed it to collect from him. But the point was made, and it's very interesting to read the transcript, how he spoke after he had been found in contempt and realized he'd been found on contempt. It's real interesting reading. Whole different attitude on his part. Okay? So, but that's what contempt is. And this court also has, or this case here also has all the logic that's necessary. If you go down to the ruling, here we are. Let's see, where's the ruling? On here someplace. I know there it is. We go down to the ruling. All right, this is a ruling on contempt, all right? And then here it is, a little more. We go down to the ruling on that. And this ruling is the one where we found him in contempt of court. It's also the same ruling in which we found the clerk not in contempt, even though she was accused earlier. But what I'm pointing out to you is we have the judicial cognizance. Now, what's the difference between judicial cognizance and judicial notice? Well, in judicial notice, you basically, the court with a judicial notice notices things that are of such high quality that they do not have to be proven in evidence. For example, you can take judicial notice of the statutes, the Constitution. You can take judicial notice of official records. It doesn't mean they can't be impeached, but as long as nobody impeaches it, you know, they're accepted at face value. So a judicial notice, basically when the tribunal is evaluating for a final decision, taking judicial notice of something means you kind of put it into the cause, and you kind of decide, does this apply or not apply, and you see how it fits with the picture. Okay? Judicial cognizance is a notch up above judicial notice. In judicial cognizance, it is mandatory that the judges apply that particular law or that particular thing that's being judicially cognized. I guess I made up a word. Okay? And he has no choice. If he's passing judgment on something, he must apply that thing you're taking judicial cognizance of. Can't ignore it. Other things, if he makes a decision and that decision goes contrary to something that was judicially noticed, he simply says, well, I evaluated it and it didn't apply. But if it's judicial cognizance, he can't ignore it. It must apply. All right?
How would you word that?
Huh?
How would you word that?
Well, read this example. It's in there. It's right there. The court takes judicial cognizance and decrees as follows. Okay? Court takes
There it is on top.
Yeah, it's right on top. Okay?
There it is.
You got a low-level feedback there. You got
Is this done after decision or what?
turn the volume down.
It's already turned up.
Boy, I hear low level. I think, or maybe it's just something. Whatever. Yes.
Do you file this or whatever after a decision from the court that you don't think he's?
No, this paper is the court itself speaking. This is a decision.
Well, this is not the court of record.
Yeah, it's court of record, but the court's making a decision. The action's over. It's now a decision. This is the paper that was filed.
Well, then you file it.
This is the actual decision. Right. Let's take it to the top.
I see it.
All right. All right. Right there.
Got it.
Ruling regarding motion for contempt. One of the parties made a motion for contempt. He says, this guy's in contempt. Here's the reason why. The judge said, or not the judge, but the court, right, the person in suit of the sovereign. The court said, you're right, he's in contempt, and here's our ruling. So you got a summary. It's written in a style very similar to what the Supreme Court does when it writes rulings. You know, you tell the story. What happened? Why are we here? How did we come up, our reasoning process where we come to a conclusion? All right? So this ruling has everything you need to know about why it is you outrank the judge. It has all the information. You should study this. This is a real complete picture. This one ruling tells the whole story. And you know, when we started this case, we never expected to have this jewel show up. I mean, we made it, we created it, but we created it out of the situation. We've issued orders many times, never had them challenged. This time the guy issued a second order. First judge to issue a second order, okay? But the second time he knew better. So now he's in contempt. First time we gave him a free ticket. We just issued an order vacating his order. But the second time he knew better, so we found him in contempt. Because he was in contempt of our court.
Now you had, when you were in court, you had to take time to research and come up with this.
Well, of course. Yeah, it's not easy. Freedom's not free.
So you actually tell him the next hearing will be in 30 days, such and such, or whatever.
Well, whatever, but the thing is...
Our court is going to convene here in 30 days on such a day, such and such a time.
Yeah, well, I'll tell you, we made it real easy. We scheduled the hearing for the next conference. In other words, they had set a date, so we made it the same date, so everybody would be in the courtroom, whether they liked it or not. Okay? They thought they were there on judge's orders. They were actually there on our orders, but we don't quibble. So, but the thing is that this is a motion for contempt and a ruling on it. Yeah. Now, I gotta entertain you with something here. This judge had repeatedly, and we had it in transcripts, we had it, lots of examples. He repeatedly tried to invoke California rules of court, California statutes, okay? And this is that law. So the only law that exists in this court is the law that's decreed by the sovereign. But he was insisting on California rules all the time. So, here's what we did. See if I can... Take me a moment to get down to it. I'm still in the judicial cognizance section. Let's see. Yes, take me okay. Okay, here it is. You'll love this. Listen to this one carefully because this is entertaining. So anyway, in this instant question, the magistrate unduly chose to personally bypass all procedure, direct the court deputy clerk to reject the first amended action, and then sign the accompanying pre-printed order without proper hearing or notice to any of the affected parties. That exceeds the jurisdiction of a magistrate who only possesses ministerial authority separate from the authority of the independent tribunal of a court of record. On more than one occasion, the magistrate has indicated his preference for California rules. So be it for his cause. This court, for purposes of accommodating the accused's choice of law, adopts the California Code of Civil Procedure as it relates to contempt of court. Let there be no doubt as to the justness of this proceeding for the accused. How do you like that? What happened? What happened was the court, didn't I tell you, you got to put on a good show? How better could you improve a show than by accusing somebody, determining what law system he prefers, granting that wish, and then convicting him on his own choice of law? How could you be more fair than that? Right? That's what we did. We suspended the entire common law system by sovereign prerogative, okay? Brought in another legal system, totally independent. This is your choice, man. So then quoted all the statutes and codes and whatever, convicted him, then throw that out and bring the common law back in. Well, sovereign prerogative, right? That's what we did to him. This is what makes this case this particular thing, this contempt, such a jewel, because what we're showing here, if you study this, you are going to see the full flexibility of a common law court and the full flexibility of sovereign authority. Okay? You got it. And they respected it. We never had a kickback on it. Okay? As a matter of fact, what happened was when this guy left, they brought in a new judge. Well, he seemed like an ordinary guy. You know, of course, that's what he's supposed to look like. All right? But we researched him. Now, you can go down to the library and you can get what's called a judicial profile. They keep a book, loose leaf binder typically, and in it they have 1, 2, or 3 sheets that is a background report on the judge. All judges have it. So you look at the judicial profile, they tell about, you know, like he's married or single, how many kids, his history, where he graduated from, and what his hobbies are, interests, and so forth. So you kind of get a picture of who it is you're dealing with. And let me assure you, they don't say anything negative about these guys. Okay, it's all positive. They're wonderful creatures for society. Well, we looked up this guy, the new guy. We found out that he was a specialist in common law. In fact, he loved common law so much that he was a member of a judges group that all they do is study common law. They love it. So they brought in their top gun, okay? And he just pretended he assumed this case and the other 900 cases, you know, just taking care of business. Then we also found out that at one time he was the presiding judge of the Superior Court Appellate Department, which is usually your sharper guys, okay? So they really did bring in their top gun to handle this one. They felt desperate. They felt desperate enough to pull out this guy and bring in the other. Now, there was one little problem that they had with that, and that's this. Who's boss? Right? They're in my house. I'm not in their house. First of all, I'm one of the people. I own the outfit. All right? One of the owners. Secondly, it's my court. I set the conditions. When I came in, I decreed right up front. I didn't call it a decree, but what I said is that I am so-and-so, one of the people of California, right, that establishes sovereignty, and in this court of record, blah, blah, blah. Nobody objected. That means they agreed, didn't they? Well, once they agreed to the forum, they can't change the forum. They brought the new judge in. This new judge had no more authority than any other judge. Here's an example of a judicial profile he just brought in. Okay? Has a nice picture of the judge. Talks about, let's see, when this lady talks to law students at her alma mater, she gives a lot of advice on taking the bar exam. She offers the tips at the Whittier College School of Law, not only as a municipal court commissioner, but as a co-owner of a testing service that offers a bar review course. And they go on and they tell all the good things. And here they have 3 pages. They have a biography, comments on trial court procedures. Do you render tentative rulings in law and motion matters? No. Are you willing to resolve disputes that arise during depositions over the telephone? No. And so you get the policies and styles. So yeah, this is an example. A commissioner, see? Yes.
I actually had the last attorney before he substituted.
Can you talk up, please?
Just talk louder.
Okay. I actually had the attorney of record that substituted himself out tell me one of the ways that he got me to be his client was he said, I know the judge. I used to practice tenant landlord with him, and he's not too bright. And I was like, what kind of a thing is that?
Well, it's the usual thing. You know, that's how it works. I had a friend that was going through law school, eventually became an attorney, associated with a firm, was handling cases. He got into this one courtroom, and he had this criminal case, something like that, and these guys were going through ahead of him, you know, and he was getting a feel for about what the judge would do. And then when his client came along, the sentence was like 4 or 5 times as long. He said, wow, what happened, you know? I mean, he wasn't the last thing he was expecting, because he just had his case wasn't any different than the other cases. Well, he found out that what happened was that the law firm that he was associated with, one of the partners had run in an election against that judge. All right? And as soon as he found that out, he disassociated himself from that law firm, went to a different law firm, and things got back to normal. Okay? Yeah, that happens. That's politics. And he later became a commissioner in the LA court system. I thought, hey, this is great. I'm going to go talk to him. He's really a nice guy, actually. He didn't know beans about law. Jeez, I gave up on him. Yeah.
Where or how do you find out if an attorney is practicing?
Like a profile on attorneys, can you?
Well, I don't know of any, but you know, Martindale Hubble says, okay, that they have some profiles, yeah. And that's the set of books are about this high, this wide, about yay thick, several volumes. Heavy, good for exercise.
Right.
And yeah, law library. All libraries have them. Right. So check that out. But you know, it's tough. All right. So we got any other questions?
What did she ask about how you can check an attorney?
Yeah.
Go on the internet.
Yeah, it's another way.
Sometimes they have money.
I'll tell you.
Bar association.
But
Yeah.
they put all the good things in.
Right. Well, here's what I did one time to check out an attorney, because he was an attorney that had some experience, had been around, and had involved in a few cases that got onto appeal. And so I checked him out by looking at the appeal, going to the Court of Appeals website, because they're having that sort of thing now. And I looked for the attorney's name, and up popped every case that he'd been on. And then I read the cases and what the arguments were. And then I got a feel for why he lost all those cases. Okay? But that's what you do. So, you know, it's seek and you shall find again.
Yeah.
But, okay, so,
But ask and you shall find faster.
well, of course, if you can find somebody to do your work for you, that's great. So, okay, what's next? I'm kind of in the question and answer period. We're winding down.
Do you have any references for wonderful researchers like yourself that's not available?
Any references for what?
For wonderful researchers that can look at...
People, you mean?
Yeah.
Who you can go to for research?
Yeah.
Uh,
That look at the case and find every I that's not dotted,
You
that's not crossed.
are your own best researcher. All right? You're your own best researcher. And nobody's as interested in your case as you are, all right? And yes, you can do research, you can hire somebody, but it's never the same quality. And remember, it's expensive. You want to hire somebody, I mean, a good researcher is worth $75 an hour or $100 an hour. Oh, yeah. Well, you know, if you got the money, great. You know, but
When's your next talk and where?
I don't know. I haven't planned one yet. What would you like to hear about on the next talk? Hopefully you got your money's worth this time.
Whatever you didn't talk about this talk.
Well,
when we left for dinner, I don't know if we covered it actually, but we were going to talk. You were going to speak on general motions and orders.
oh yeah, did I drop the ball on that? Yeah, let's go back. That was again Matthews. Okay, and all right, we go to law notes, and then we go to procedure, and then we go up to motion example, and then we go to no, I guess it isn't that, is it? No, it's back here on, here we go. It's on reference law books, I believe. Matthew Bender here, forms of pleading and practice, okay? And then we were going to talk about general motions and orders generally, okay? Here we go again. I guess I'm going to have to work on this, huh? Let's see. This is motions and orders. Well, I sure put this together in a hurry, but we can get to it. We just eliminate that specific file that it's looking for. Hit enter. That gives us the general directory. And now we have motions and orders right here. I think this is it. Right. And this will bring it up. Huh?
We have to fix limiting. Add the extra I.
Oh, okay. So, all right, so now this is really the same organization as before when we went in limine, motions in limine, okay? This is just, but this is a general discussion of motions. And keeping in mind what I told you about the organization of motions, keep that in mind as you look through this. So, it tells you here, this chapter includes forms of, okay, notice of motion, supporting declaration, written statement of oral evidence sought to be introduced at the hearing, separate notice of intent to appear by telephone, orders on a motion, okay? So these are different things that are within the scope of this chapter. Orders on an ex parte motion. This chapter also includes a skeletal form of order to show cause and forms of written motion and a notice of hearing on written motion. Okay, order to show cause. All an order to show cause is this. If you go into a hearing without the other party, okay? Now everybody should have their day in court. I mean, that's just fair play. No matter how right or wrong, you get your time in court where you say what you're going to say to justify whatever you did or want to do or so forth, okay? So, but sometimes that isn't always possible. Maybe you have an emergency situation or something. So what you do, you might end up in court ex parte, meaning without the other party. Now, sometimes a situation comes up where it's so important, so timely, that we don't have time to go through the normal channels of putting together a motion and then having the other person respond a month later, you know, that kind of thing. So, for example, the court itself might make a motion. You say in your paperwork, the court on its own motion does such and such and issues this order. And so you say that right in the paperwork, that it is originating with the court, not with the parties. So you issue this order. Well, is that fair to subject anybody to an order without ever hearing from them? You know, you heard some situation, whatever it is, and the court decides to move on its own. Well, of course, it's not fair. So what you do is you issue the order, you put all your reasoning process in, the whole shot. It's just you haven't heard from the other side or from whoever's affected by it. From whoever's affected by it. So, in addition to your order, you have a second order. And this order is called an order to show cause. And what you're saying is, all you folks out there that are subject to the first order, if you do not obey this second order, then you must come back and show cause, or in other words, show a reason why you disobeyed the order. Because maybe the court issued an unrealistic order. The court could have said that we declare an emergency and everybody must walk around at least 1 inch above the floor. Okay? Well, obviously that's not realistic. So you get an opportunity with a show cause order to come back and say, well, I can't walk 1 inch above the floor because I don't have my flying shoes and they haven't been invented yet, or whatever the excuse is, you see? But you always issue an order to show cause whenever you do something without the other party. When we issued our orders before a hearing, yeah, that's what we did, order to show cause. That's very, very important. It keeps you out of trouble, too, because, you know, nobody can argue. And you know what the beautiful thing is? They never show cause. I've never had them come back and show cause. Okay? Yes?
So does that mean if you don't show up in court, I thought usually just lost by default?
Well, normally you do, sure. I mean, that's
but are you
typical.
saying that when you lose by default, then there's an order in there that orders you to do something, and then...
Well, it's not magic. I mean, when you're served with the order, you're also served with the order to show cause. Okay, that goes with the package.
Can't you do that rather than a notice of demand?
All right, you're missing the point here.
So what I'm saying is, so you don't, even if you've lost by default, you still have a recourse because then you're challenging this order to show cause?
No, you didn't lose by default. What you got is an order.
Uh-huh. So that's
Losing by default means that you didn't pay any attention to the arguments, and after you did not show up, an order came out affecting you.
Mm-hmm.
This is the order already came out, and it affects you. Okay, so there's no losing by default. You've already lost if the order adversely affects you. But now you're in a position of not obeying the order.
Oh, I see.
Okay?
Yeah.
So, well, maybe the reason you're not obeying the order is that there's no such thing as flying shoes. Okay? Or whatever. So you've got to come back and say, I did not obey the order because. But see, that keeps you from being in contempt of court. But it's the other way around, too. When you issue an order out of your court, you also, and if the parties have not had a chance to present their arguments, you must put an order to show cause with it so that they have an opportunity to speak if they're not going to obey the order. Because you can, it's possible. You're in what do they call it, an ivory tower, and you just don't, you don't know reality out there. So you always give the other side an opportunity to express it. But like I said, I've never had anybody come back and show cause on any of my orders. They just automatically stick. Okay? So, what's next here?
I don't think I understand challenge jurisdiction as well as I thought I did. Is that pure and simple, provide a person that swears they were harmed, or is there more to it than that?
No. All we're saying by challenge jurisdiction is that they did something, whatever it is. They took jurisdiction. How do I know they took jurisdiction? Because they're ordering around. They're suing you. They're taking jurisdiction. They're saying you're a bad guy, and because you're a bad guy, we want damages, or we want to put you in jail, whatever the reason is, okay? You're saying, so that's the jurisdiction, because you can't go to the beach anymore. You got to be at the court hearing, whatever it is. All right, so Now what you do in your counterclaim, you say, hey, what are you guys doing? You know, you use better language than I'm using, but you're saying, you know, what are you guys doing? You don't have the authority to do this. You know? Before you proceed any further, either show your jurisdiction or pay for my injuries. Because my injury is that I lost my right to freedom. I now have to work at your direction. You're telling me to file answers when you don't even have the jurisdiction to sue? Or you don't have the jurisdiction to arrest me or whatever it is? Okay?
But they will say, we've already shown you jurisdiction. That's why we sued you in the first place.
No, 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 no. They haven't. They got to prove the jurisdiction. It isn't enough to just say, oh, we got jurisdiction and arrest you. It's not enough to say that, well, the penal code such and such says it, so and so and so and so. Because your issue is you're sovereign. You're not subject to the penal code. Okay? Is it an act of treason to go against the sovereignty of the state? It's a good question to ask, you know. All right? Because government code, which they are subject to, you're not, but they are, specifically says the sovereignty lies in the people, and it also specifically says that the people do not yield their sovereignty to the agencies which serve them. If you're an agency that serves the people, what are you doing going against the sovereignty? I'll put that in legal language, but that's what I'm getting at, see? So that's your challenge. You sue back, and you say, because you guys went against the sovereignty of the country, you went against me, one of the sovereigns of the state. You are committing a treasonous action, or could be, depends on how strong you want to word it, you know, and you say, you've injured me by this action of yours. Time out for tape. Okay, you're saying you've injured me by taking over like that. By what authority do you presume to take over the sovereignty? Okay? And if they don't show it, then I want damages for my injuries. You understand? Injury is the injury. Damages are the money owed to you because of the injury. Okay?
So, that's great. So now, if the other party can't prove their damages, and you go ahead and you counter...
Well, that's what lawsuits are all about. No, you don't go ahead. You already did it. That's why they can't prove it.
Right.
You said if they can't prove it, that tells me you already made the challenge.
I did.
You already did the counterclaim.
I did.
Oh, okay. Well, then what's the problem?
I mean, I didn't do it yet. No, I didn't do it yet. But they don't have... I mean, this guy can't prove damages.
Well, wait a minute. Did you raise the issue or not?
No.
All right,
No,
if you
not
haven't
yet.
raised the issue, then don't talk about it like you did.
Oh.
Okay? Put it in future tense. Okay? You're going to raise the issue. And if they can't answer it, yeah, then they lost the suit. That's what you're suing for, right?
And then I can go ahead and sue them for the damages for taking my freedom away for the last 2 years.
Well,
and
you
all
make the
projects.
accusation, and if they lose, then yes, you claim your damages. Right. That's exactly right.
Because I have great doctors and great producers that can actually prove.
Well, that's
that I
wonderful,
wasn't
but you
able
have to put it in paper and you have to sue them for it.
Okay.
But remember, you're not
Right.
suing for what the great doctors say. You're suing because they took away your rights, maybe, or whatever it was.
Yeah.
And you're saying, what was your authority to do this?
Yes.
Where does it say that you can take over the sovereignty of the state? Where does it say you can prosecute the sovereignty of the state? By what authority do you override the government code which says that the people do not yield their sovereignty, and you're forcing me to yield my sovereignty to you? Where did you get that authority? Okay? Does the government code mean anything or not?
That's great. Does that tie in also
right.
to malicious prosecution?
Well, malicious prosecution is a little more delicate. Again, malicious prosecution is a very common thing. And what you do is you go to Matthew Bender, which I did not prepare and study that particular item, but it's in there. I think I've seen that one. And they'll give you all the criteria for what malicious prosecution is. You look at it and decide whether or not your case fits. Okay? And you can pick up and do a lot of this stuff. By the way, all of these cases that we talk about, that you've brought up this whole evening, generally fall into two classes. One of common law classes. One of them is called trespass, and the other one's called trespass on the case. Now, trespass means that there was violence involved. Okay? If you are injured, you lost some blood, you got some bruises, that's trespass. All right? Trespass on the case is more administrative in nature. If there's no violence, then it's trespass on the case.
Physical violence.
Well, yeah,
They'll
violence.
put you in jail, then it's, right.
Yeah.
Mental violence.
False arrest is considered trespass, even if they were very gentle with you. Okay? That's a physical taking of your body.
If they took your money, it's a trespass.
Right. That's the physical stuff. It involves involves force. All right? That's different from an administrative thing where somebody says, oh, by the way, you owe me money. Well, that would be trespass on the case from your point of view.
If they physically took money, then it's trespass.
Yeah, but if they send a bill to you saying you owe me money and I'm going to sue you for it, and they publish out there that you're a deadbeat, you don't pay your bills, and ruin your reputation, that would be trespass on the case because there's no violence involved. It's just a.
But if they physically took money, then it's trespass.
Well, how many times do I have to tell you?
Let's make sure it's not changing.
I'm trying
Yeah.
to get that very clear because when they take property.
I thought I was clear.
Without a court order.
It's physical. Force was involved. You have to use muscles to pick it up.
What about if a person, like a construction worker that was, what about a construction, sorry. What about a construction worker that actually assaulted me physically?
Sounds
I
like
was
violence
working
to
for this
me. That's
guy.
trespass.
And the city attorney awarded me that. And there's a
I believe there's, I mean,
actual
how many times do I have to
pictures.
tell you?
Yeah.
Physical
Okay.
violence is trespass.
Great. So
Okay.
if it's such a great case,
Well, if you have such a
why
great.
have I been so freaking persecuted?
Well, because it sounds like you had people that are not on your team. They're against you for whatever reason. I don't know. You haven't told me enough about the case for me to. I can't read your mind. You know, I mean, basically, if you got trespass on the case or trespass, that's for you to decide. Where's the violence in this? And where's the physical action as opposed to administrative type or non-physical? Ruining your reputation is non-physical, but putting you in jail is physical. Okay, taking your property is physical. That's the trespass. And you've got to determine, classify these things, but you always sue for both anyway. If it doesn't fit one, it'll fit the other. Yes, sir.
Okay, to research more vindictive prosecution as opposed to malicious prosecution, we can't really go into the civil stuff from Bender, forms of pleading and practice and P&A, because that's civil. This is a criminal complaint the city is trying to do. So what we do, go into Witkin criminal procedure, or?
Well, Witkin criminal procedure would work, but so does Matthew Bender. They have criminal stuff in there.
Get the civil first and then go to the criminal?
Well, I don't know about that, but why not?
Or does Bender have criminal?
Wait, which one can you move fastest on? You know, do your research. Look up both. You're in the library, right? I mean, I don't want to sound petty about this, but look, you got to look and see. I don't know which one you do. You know, I'm going to slide under a rock and disappear when you start asking me questions about what to do in your case, because you never give me enough detail. I'm giving you some of the general theories. Our whole evening here, by the way, and what I prepared for was to answer specific questions about form of motions. Now, we got a lot of side issues in there, too, but I didn't come prepared to answer those kinds of questions. Okay, you can't know all the answers on everything, but I did prepare for motions, and here are the physical things, and here's the resources for the motions. Yes?
So how long did you educate yourself before you tried your first case?
I didn't have a chance. I was pushed into it.
Right.
Okay, so, you know, I mean, everybody gets desperate once in a while.
So you went in there completely blind and then had to started educating?
Well, what happened is that I had a cause. I had a dying father, and people were doing things that affected his security, his life, his home. And so I was there to try and I was really after to stabilize the situation and take the worry, the load off of his mind. Okay? And so here's these clowns out here just trying to make life hard for him. All right? Well, and all out of greed. All right? These people that were taking care of him got him to sign over the title, overdosed him with actual prescription drugs, had the paramedics taken to the hospital, and while he's in the hospital, they sell the home and disappear with the money. Okay? Now, in anybody's gut, you know that's wrong. But when you go to the court and the court tells you that they're leaning over backwards to give you the benefit of the doubt because you don't have an attorney, and then you keep losing the motions and things, that tells you that the courts are not working as advertised. So, and you're in this constant battle of they hit you with a motion, you're trying to live, and you're trying to handle the case at the same time, and you're trying to learn at the same time. So, life is tough. So you meet the challenge, okay? You have to rise to it. If you're going to spend nights without sleep, that happens. And so you go, you do it, and so I had a great opposition attorney with absolutely no integrity. And he did everything, and boy, he kept me running. Well, that's how I learned.
Right.
You know?
Trial by fire.
Yeah, you know, there's a story about this guy. You get a lesson from this, okay? There's a story about this guy that he wanted to be a great swordsman. This took place in ancient China, I guess it was. So he goes to the man who had the big reputation for the best swordsman in all of China. So he goes, he says, I want to be your apprentice. And the swordsman says, go away, kid. You don't know what you're getting into. Just go away. Well, he's persistent. Took him about 2 or 3 years, but he finally got the guy convinced, yes, he was serious. He wanted to be a swordsman. So finally the swordsman says, look, I'll take you on as an apprentice, but only if you do exactly everything I tell you without question. You must obey every instruction, okay? So yeah, he wanted to be a swordsman. He says, all right, he says, here's your sword, wear it at all times. For the next 2 years, that's all he did. He washed the dishes, he cleaned the house, he did all, or cleaned the cave, I guess it was. But he did all this stuff, and he's wearing this dang sword, and 2 years, nothing. When are we going to learn, you know? You said you're going to do everything, you're going to do it. So he had to live 2 years with this sword. Well, what happened? It became a part of him. After 2 years, he's doing his work as usual. All of a sudden, bam, he gets hit by the flat of the blade from the master. What was that for? He says, you weren't on guard. Okay? And from that moment on, for the next, 3 years, there was no peace. He was under attack all times, day and night. Okay? And that master just harassed him to death onto this. Well, eventually the master died from old age, and he became the new master swordsman of the country because he lived and breathed it, and he just was, you know, constant. It's what you have to be a good swordsman. Well, same thing happened to me with law. Every moment this guy's throwing motions at me, and by the way, I was throwing motions back at him, okay, because in my research and defending against his motions, I found stuff to go after him. And so I was moving for consolidation of cases. I was moving for contempt of court. I was doing all sorts of stuff, but I was always depending on the judge, so I always lost. But, you know, at least that's how I got my education. So I learned to be versatile because of the heat of the fire of the courtroom. And this is what you've got to do. You want to learn this stuff, I come in here, I'm very glib, okay? I make it look, oh yeah, we do this, we do that. You've seen speakers like that before, right? Well, I'm just one more in a long chain of speakers that's glib about things. But I'm giving you one thing that's different than all the other speakers. I'm telling you what the next step is when you walk out of this room. And that next step is you absolutely must link together. You've got an issue you keep talking about, you've got an issue, and so forth. Gather up other people who are here. No one person is going to remember everything that I said, okay? You have what I call a group mind. So one person is going to remember what the other one forgot. And as you explain it, you know, you remind each other. That explaining process crystallizes things in your mind. There is no way to learn a subject better than to teach it. Okay? A doctor when a doctor goes through school, medical school, he gets through the routines and so forth. Now he gets into residency. The doctors have a saying. They say, see one, do one, teach one. And what they mean by that is, let's say you're learning surgery. You see how it's done. Then after you see how it's done, you actually go in and you do one. Of course, you have supervision and so forth, you know, by the expert, your co-workers. But you do one. And then after you do it, you teach another doctor how to do it. And it's that teaching that does the crystallizing. So you've got to get together in the group. Questions will come up. And when you argue back and forth, you're actually teaching each other. Somebody remembers something someone else didn't and says, well, this is how it's done. This is what he said. This is what this is what my research covered. Then you will get the benefit. If you don't do that, you wasted your money tonight. Okay? You must get together. And I'm happy to put on more things to talk about if you have questions, and if you want to have situations where you all get together and we hash out a specific problem and strategize. That's fine. I'm happy to help. But you must interact. No interaction means no mental capital has been built. Okay? And I'm telling you, this is so important. There's one guy that has done very well with this up north, and some of you know him, Al Thompson. Now, he's got a little problem right now. He got rearrested. Okay? Yep, yeah, he's been rearrested again. And no, about 2 days ago. 3 days, right. So they came after, and he doesn't even know what for. He said they just grabbed him off the street. So whatever it is, but you see, Al Thompson is an exception to the deal. It's true he studied all this stuff, but he's also a political target. They don't want him for the money. They want him for the headlines. See, he's become a big enough name in the headline business, the newspaper business, that anything happens to him, he's in the headlines, okay? He's been on 60 Minutes. So this guy has got a special problem, which I don't know if we can help, because, you know, the powers that be do know how to break the law if they're desperate enough. And they're desperate, plenty desperate with Al Thompson. So he's kind of an exception, but he has done very well. He's quashed subpoenas on his own order, you know. He's beat them at their system. When he was in court this last time, and when he was in jail last time, he did 80 days. And the judge said to him, are you going to obey the order? You know, they were holding him those 80 days for contempt of court because he refused to sign the papers. Okay? And so he said no. He says, I'm not going to lie. Okay? And he says, and he demanded to be released. Well, the federal attorney who is on telephone presence calling from Washington, D.C., the federal attorney is saying, Your Honor, he says, we can't let him out. Sometimes it takes 1.5 years to coerce him to sign. He actually used the word coerce. Yeah, we got that on the record. Okay? So the judge cut him loose. He was out of jail. From the moment the order was given to cut him loose till the moment he got on the street was 2 hours, which is record time to get out of jail. You know, usually they let you out like 3 a.m. You know, you got the order in the morning, and it took him that long to figure out how to get you out of jail. No, he was out in 2 hours. And he's using all these techniques. But he's got, and I've tried to warn him, I've told him, look, you're not just a litigant. You are a political entity. And as such, there's political capital to be won if they can beat you. And they're going to do what they can. And I've told him to be aggressive and to go and sue them. Well, he delayed and delayed and delayed. Finally, they figured out another way to attack him. We don't know what it is yet, okay? But they have. So, you understand, it's not an easy fight. Be nice to everybody. Yes, sir.
We were discussing something early. If you're suing a public official,
yeah,
can that public official use the attorneys of the public entity they work for to defend them?
Whether they do or not, you have no control over that. You know.
Well, no, I'm just saying, can they use that to defend them if you're suing them in their personal capacity? Because that means the taxpayer, the people, me, is paying for his attorney.
Let me tell you what happened. one time there was a case where this person sued personally sued one of the, whoever he was, some person working for the government. The government came in and said, you can't sue him, he worked for us. You should have sued us. So the plaintiff said, great, added them as a defendant. Okay, glad. Then they said, you can't sue us, you have to go to the Court of Claims first. Okay? So that got up to the Supreme Court. The Supreme Court said, nope, don't have to go to Court of Claims. Because why? Because they volunteered to be defendants. Okay? It was a contract, right. They agreed, and so they waived the Court of Claims. So that's what happened there. And they will do that. And so if you sue a federal official in a state court, and then they remove it to the federal courts, what I would do is I would enter a motion, or not a motion, but I would enter a notice to the court of, let's call it, see, you can make up names. I would say notice of concurrence. All right? Means I agree. In the body of it, I would say that, plaintiff, because you're the plaintiff, right? You're doing the suing.
Right.
So you say, and I agree, yes, this should be in federal court. No problem. Now what happens? You get in the federal court. Who's the plaintiff? Right. Who's the sovereign of the court? Right. Whose suit is it? Right. It's your court anyway. Makes no difference whether it's state or federal, because the court is wherever the sovereign and his following, his courtiers are. I forget how it says it in the dictionary, but something worse to that effect. So you can be in there and you still issue your orders. You have a good time.
Well, that wasn't the issue here. It was always in federal court.
Oh, okay. Well, then fine. But who's the plaintiff?
The commissioner in a municipal court.
The commissioner's the plaintiff?
No, no, I'm the plaintiff. He's the defendant.
Okay, so what's the problem?
Well, it's just that the Attorney General decided 2 weeks ago to step in as his attorney.
Well, fine. Now, let's say he steps in as his attorney. You're talking about the state Attorney General? In a federal court?
No, it's a federal court. Yeah,
it's a federal court, so he's stepping in. All right. Well, here's an issue that you could raise. Again, this is strategy. I'm not saying you'll win. I'm just saying here's a technique to kind of hit back. All right? Well, I think a legitimate question has been raised. You say, by what authority does he presume to represent this guy in federal court? What's the reasoning? All right? Now, in the absence of a good reason for being there, it looks to me like there's a conspiracy here. It looks like a Title 18, Section 242 violation.
Ooh.
Conspiracy, right? When two or more go upon the highway, and blah, blah, blah.
Yes.
Right.
Yeah.
So I would bring in an 18242 and just see where this goes. Now, I might be wrong. It might provide reason, but sure be fun. Let them think about that one.
Well, hypothetically, that's actually one of the things we were looking for.
Sure.
But if they claim, well, he's our employee, now that brings the name
Oh,
suit, doesn't
are
it?
you telling me that top management certifies that this is state policy to do these things? Wonderful. I love volunteers.
Yeah, because that
Sure.
would volunteer them into the case,
Sure,
wouldn't it?
that's what I would do, yeah,
Okay.
Like, any way they go in this sounds good to me so far.
It sounds like they just made deeper pocket.
Yeah, I love deep pockets. Now instead of having to deal with his salary, you deal with the entire budget.
No, they already stole all that.
Yeah, well, that's true. If you read this bicycle case, the example that I was telling you about where we had the contempt, you really ought to go and look at that first amended action. All right, now what that was about was that this guy was riding his bicycle, and somebody came through, stopped at a stop sign, and then started up again and hit him, causing $50,000 to $100,000 in medical injuries. Okay? So he wanted to collect. Well, it turns out under state codes, and by the way, this was a minor who was a licensed driver, legitimate, okay, is very fine. But the codes say that a minor who gets in an accident has a limited liability of $15,000. It also says that the parent of the minor has a limited liability of $15,000. And it also says that the aggregate total of minor's liability plus parent's liability is limited to $15,000. And they had a $15,000 insurance policy. Well, that's fine. We were happy with that. But what we did is we said, well, the state of California licensed this person. What's a license? A license is a partnership. Okay? A license is taking responsibility for the quality of the product that's involved here. In other words, how good does she drive? There's no question it was her fault. Okay? And there's many court rulings that have said that the state loses its limited liability protection when it is engaged in commerce. It now becomes like any other company. Okay? So what we said is, well, let's take a look at this. And by the way, a lot of my writing might look good to you, but it's plagiarized. I lifted it out of court decisions. Okay? So when we get to the end point, we can bring in these courts and say, well, here's the accusation and here's what the court said. Here's another accusation, here's what the court said. This is a perfect match. That case applies. State loses. But anyway, we went through all that. And basically, the theory that we have is that the state has a vicarious liability. In other words, it has, not only does it, you see, if the state just passed the rules of the road, there would be no liability because the state's not a participant. They said, here's the rules and that's it. But the state maintains a quality control force out there called traffic cops. Okay? And if your quality of driving drops below a certain pre-designated level as measured by the number of tickets you get and the type of tickets you get, well, then they take away your license, right? So you have quality control. So they're involved. They're involved in training programs. They're involved in advertising. They're part of the commerce. So what we said is, well, hey, we don't care if the state has a $15,000 limited liability here. What we have here is a third-party intervener. And we don't care how much they protect this person as long as they're willing to make up the difference. Okay? So we're suing for $2 million. We've settled out of court with the original participants, leaving California holding the bag. All right? Now, the state of California could come back and sue them, but obviously I don't think they would do that. You know, these people didn't have anything anyway. And we're not after it. We weren't trying to make life miserable for them. It's just an accident, okay? But, I mean, it had serious consequences. But why should, you see, here's the concept. You know, you always hear about these limited liability rules and suits and this sort of thing. Well, here's what's going on. Is they're saying that the tortfeasor, the one who does wrong, shouldn't have to pay more than X amount. Well, I agree with that concept, excepting for one thing. If they don't pay, who does? Well, I'll tell you who does. It's the person who got injured. He makes up the difference. So you got $100,000 in medical bills. You got some $15,000 get paid by the tortfeasor. 15 from 100,000 comes out $85,000 is what the victim pays. Is that fair? No. Well, under common law, you know, there's always a remedy. Well, with common law, you can make up a remedy if you can't find one. All right? So we've got here a heavy participant in the commerce. So the state's going to be, we have yet to write the judgment. Well, that's our next step. We've reached that stage where I'm going to write the judgment. It should be interesting. But the case here that's on here, this is the case. It's on the computer. It's a very, it's got everything you need. Go ahead.
Do you think you could sue the state if an insurance company didn't pay for injuries that somebody sustained in an accident?
Well, I wouldn't do that. I think, don't they have a fund that protects against bad insurance companies? You know, they go out of business or something, or there's a fund like that. I would attack the fund. And the other thing is that there's another issue that you need to look at before you consider that anyway, and that's the bad faith element. Okay? There's a guy who really developed the bad faith element. It happened right in Los Angeles. All right, there was a lawsuit, and just look up bad faith on FindLaw. I'm sure you'll find cases related to that. But you, in good faith, pay your premiums. Why? Because you expect if you have a problem, you've got the promise to be covered. Well, what happens when the insurance company doesn't keep that promise, right? They took your money. You have no way to check until the day it happened. Well, this guy had something happen, and he put in an insurance claim, and I think it was something like $15 or $20 or $30. I don't know, somewhere there, real small claim. And this insurance company just really, really messed with him. And he was black, and they have a policy, no blacks get paid, okay? And they actually, through discovery, found company memos that came out and said that, all right? So they crucified this insurance company for bad faith. So the claim was $15 to $30, but the payoff was $2 million. Okay? Something to hurt the company because of the bad faith. It sounds like you have a bad faith claim.
They give it's an insurance company in New York that.
Well, they're operating in California. They've got a contract. They have a license with California. If you have it, if you're doing, I don't know, I'm assuming that. I'm assuming a lot.
My mom was in an accident where somebody.
In New York.
In New York.
Well, I don't know what they've done.
She had a claim against Geico
Yeah.
that was
Yeah, well, I don't know what goes on in New York, but I
She got
suspect.
injured, and she hasn't
Yeah.
been compensated.
Well, I don't know what goes on in New York, but I suspect that the case law that's developed out of California in bad faith would be applicable there.
Excellent. Well, the only thing is they have some kind of whatchamacallit, some kind of no-fault deal going on in New York, which makes it hard to get around in the.
Well, whatever it is, you know, you gotta look at these angles. I don't have enough information to really give you an answer. Okay.
But they badgered her. I mean.
Oh yeah, well they're going to do that, and I mean,
They're-
and public agencies are used to protect insurance interests. We've seen that a lot too, especially in the medical business. Doctors putting claims in for insurance for their patients, and then they go after the doctor's license. You know, they've been known to do that. They do that a lot in Wisconsin.
Now, I got a question for
Huh?
going back after them.
Lobby. Okay. What else do we have here? What are we interested in?
Yeah.
Don't let me get too far off track. You came here for a purpose. I'm pretty well talked out on the subject because. Oh well, we have more about motions, don't we? Make a motion? Well, it's 8:45, I think. Yeah. We're supposed to quit at 9. That's when they officially close here. Here we go. I don't know what the status of the DVDs is.
20 more minutes?
15 to 20 minutes.
Otherwise,
All right.
we're going to mail it to you with the CD.
Okay. Basically, the organization on this.
Been moved and seconded to record of record.
Okay. Any discussion? Any discussion? Oh, here you are.
Yeah, with the demur and the moving for summary judgment. Okay, so you file as a plaintiff, right? And then you said the attorney comes back with a demur.
Right.
Okay, and then, so that comes back, and then your best move is to ask for a summary judgment?
No, well, yeah, that's true, but before you do, you need to clean up the lawsuit. So all the legal things that he objected to, as much as possible, agree to him that he is right, that your lawsuit is wrong, and agree to throw that out.
Right.
But you want to leave enough because that is what he does agree to.
Right.
And often they slip up. They do this, okay? They don't cover all the points. They just cover things they think they're going to win on, except they don't expect you to make that move. They expect you to argue, see? But what you do is you don't argue. Instead, you say, yep, that's wrong, that's wrong, that's wrong. You clean it all out. What's left? All the facts he agreed to and the few laws that he didn't object to.
Right.
And you apply the law, that's it, done deal. Summary
Okay,
judgment.
and so then you win. Now, does he have the opportunity to ask for a summary judgment before you do?
Yeah, he does, and you say, great.
Oh, still you say great, okay.
Yeah, yeah, you say, because what's left, when you agree to dismiss the charges from the lawsuit, all the things you said he did wrong, and you come down to what's left.
Right.
Now, you're not going to crash your case. I mean, if you agree to everything, you have no case, right?
Right, yeah.
But you try to find the things that he failed to object to. Okay?
What if you covered all the bases?
Well, if you covered all the bases, you better use another strategy. But I'm saying they usually make mistakes, okay? They usually don't cover all the bases. They just pick highlights. Because remember, has anybody here put together a lawsuit? Nobody? You got people here who's never done a lawsuit?
I've been sued, yeah.
Either way. Okay? You must have some feel about how difficult it is to compose them and to organize it, right? It's not easy. Well, look, those guys have the same problem. Well, they have a formula they follow, but when you throw a kicker in there, they don't know what to do. Okay? They have the same problem. And you see, and you're honed in on some of these issues that all this sovereignty stuff is new to them.
They don't have a clue.
They don't have a clue. They don't have a sense of perspective like you will have.
You
So
know how to deal with that statute.
that's exactly. That's right. So, yeah, but what you do is you kind of, assuming that they've done something, they're not going to hit all the bases. They'll probably make mistakes. If they made the mistakes, take advantage of them. If they didn't make any mistakes, think of a new strategy. Maybe that's not the best one. See, maybe you can come back and say, okay, I'll revise it. And then usually the court says, yeah, okay, plaintiff has agreed that it's defective, and plaintiff will file an amended lawsuit, fixing these problems. And so you do fix them. Okay?
So, Bill, what happens if the court shines you on completely?
Well, you're the court. Why would you shine yourself on?
No, I'm not talking about your court. I'm talking about their court.
Well, their court doesn't talk because you just took jurisdiction away from them because you did a counterclaim, right?
Do they know that, though?
Well, you explain it in your paperwork. You have your case law. There's plenty of case law that says that when you do a counterclaim, their action stops.
My experience is the judge runs his own court the way he wants to. Period.
Well, have you ever issued an order against the judge?
No, I haven't.
Well, maybe that's why he keeps going. Look at this sample case that's on this CD when you get it, or go to the website. It's on there. You can just, look at that, because that's exactly what happened. We issued an order to the judge, and he went moving on later with another order. Well, we didn't just lay down and say, well, what do you do? No, what we did is we issued an order back, found him in contempt, and fined him. Okay? And if you want to know how to do that, study the lawsuit. It's there. We went through all the bases, we tried to make this a perfect case, okay? This case has been 5 years in the making. It could have been shorter, but we wanted it to be a show place, and we thought through all the reasoning process, plugged all the holes we could find, and so forth. So you really do have a good model. And if you study that and you learn it and you discuss it among yourselves, you're going to find that everything is in there that absolutely strips the judge of his authority and puts the authority in your hand to find him in contempt.
Which particular case are you speaking?
Yeah, it's the one that's called Example. Okay? Yeah. 1215.org. That's the website. It's the one that's called Example on there.
Yeah, example.
The example. How many times have I clicked on example to show you something? Yeah, about 3 or 4 times. Yeah.
Now, if you're going to do a counterclaim,
Yeah.
is it titled a counterclaim?
Sure.
Yes.
Okay, so it's called.
But understand it's only a title. That does not
Understand.
control. What
That's
controls is the body.
Now,
Just the other day, I filed a case that was a counterclaim, and the clerks got all excited. So I said, no problem, we'll change it to complaint. Didn't affect the body. It only affected the title. Now they were happy, and they filed it. Okay? Don't worry about it.
all right. Do you have an example of a counterclaim? Is that, or is
A
this just?
counterclaim is identical to an original claim. The only difference is that you did it second instead of first.
All right.
Okay? All the same wording, but you give it that label, counterclaim, And then what is the issue? Number one issue in any counterclaim. What is it? That's it. You got it. Jurisdiction. So challenge jurisdiction. Why jurisdiction and not some other? Why?
Because nothing else happens without jurisdiction.
You shut down their case until they prove the jurisdiction to your court. Okay? That's why you pick jurisdiction. There's many things you can sue for, but that's your flagship item. That's what you go after on jurisdiction, so that they have to stop their case. They cannot proceed until they prove jurisdiction. Got lots of case law to support you on that. So, use it.
Now, when you're building it, you have, again, the two boxes on the left-hand side, and you are listed as the counterclaimant.
Yeah.
On that one down below.
Right.
Correct?
Or, well, the other guy was. That was, I sued first and they sued second.
Right.
But that wasn't a counterclaim. That was a countersuit.
No, but I'm just saying that is how you would do it.
Yeah,
you would
that's
be
the
listed
form.
as the defendant up
Right.
here and the counterclaimant down
Right.
here.
That's why I put on there to show the form.
Okay.
Sure.
After jurisdiction, then you've got damages?
Well, yeah, you have injuries because they exceeded jurisdiction.
Right.
It affected your rights or whatever. So now you suffered an injury. Now you place a value on the injury. That value is called damages.
Right.
The word damages means money.
Okay.
Okay? Damage does not mean injury. Damage means the money that the injury is worth that you want to collect.
Right. And then after that, you go to your points and authorities?
Well, yeah, you decree the law if you're talking about a lawsuit. You say the law of the case is blah, blah, blah. And you look at this, look at this First Amendment action. That was done correctly.
Okay.
Okay?
Thanks.
Yes, sir.
What do you do to... the judge is going to want to take control right from the beginning, so what do you do to disqualify him or put him in his place?
Well, first of all, you filed the lawsuit, didn't you?
Yeah.
That disqualified him. Did you say in your lawsuit that you're one of the people of California and in this court of record complain of?
Yeah.
Well, that did it. In a court of record, is the tribunal independent of the magistrate?
Yes. Yeah, but there's...
Well, there you are. You suspended the judge as far as, okay?
But then they'll, like you were giving an example of how they
the first
will
time
rule
you,
anyway.
Look,
sometimes.
the first time you're in court, he won't know it. He'll read your papers exactly the way all the attorneys read it. Say, oh, yeah, people, yeah, all right, court of record.
Only one at a time.
He'll say, people, yeah, court of record, okay. So he buzzes through that. Everybody knows a court of record keeps a record of the proceedings and has the power to fine and jail for contempt. They don't know the other three requirements. They look it up in Black's Law Dictionary, 5th, 6th, 7th, or maybe now 8th edition, okay? What do they see? Court of record. Oh, yeah, has the power to fine contempt and keeps a record of the proceedings. That's all they know. That's policy. That's all they want them to know. So then they fly off at the handle. They do all this sort of stuff. Well, then the first court session is never going to go your way because they don't know. Even though you put it in front of their eyes, they still don't know. So it's when they do something and all you do is you don't argue. Whatever they do that you don't like, you just say, I object. Why do you object? Well, it's not my wish. Now, I'm speaking as a plaintiff, okay? Okay? If that's the best you can do, you're overruled. Well, for the record, I do object. Okay, noted. Noted in the record. Moving on. Next issue. Whatever it is, I object. Okay? Same conversation. If there's enough of them, he says, yeah, I know, you object to everything. Well, thank you. Now I don't have to say object anymore, see? As long as it's on the record. So you object to everything. Well, the thing is that that's only for the time you're in the courtroom, and that makes it real efficient. You know, it costs money to get transcripts. Okay? Transcripts can get very expensive. But my transcripts are only 5 minutes long. I typically pay $30, $40 for a transcript instead of $150 or $200, okay? And then what I do is I sit down, I write my order, vacating the judge's decision, explaining in my order, and you have an example, and this example has all that in it. And I explain, the judge, you know, I'm one of the people, the sovereignty, the whole thing, it's all there. You got a chain of logic, it's logically arranged so that one thought leads to the next, so you don't have holes in it, all right? You have the preamble, the Constitution says the people, you know, ordain and establish the Constitution. The people are relative. I don't know what people are, but I know that relative to the government, they're boss. okay, because we ordain and establish it. And so you just go down through that chain of logic and in your order, and then you say, because of all this, you know, the judge has no authority to overrule the sovereignty of the case, and so you vacate his order. You order it out. And then when he reads it, you know, that's when he gets educated. And if you want to know, whether or not this works, on this example case that's on the CD, and you don't have to wait for the CD because it's on the website, 1215.org. You go to that website and you click on the example and you read the transcripts. It tells you how the judge reacted the next time we met him, okay, in court. And it's fun. He stutters, he stammers, he's trying to collect his thoughts. The attorneys there are saying, well, Your Honor, is that an order? And the judge saying, well, it's all in the paperwork, okay? I mean, really, you look at that, you compare the very first transcript. It's kind of mild. The judge was fairly, I'd say reasonably friendly for a judge, okay? But no question about it, he has a position of being in charge. That's his attitude in the first transcript. Then he makes his order. Then we reverse his order. And then we have another hearing of some kind, whatever it was. You read that second transcript, there's a whole different attitude base that he has. Completely different. Because he knows he's been had.
Do you submit the order on the first day?
We don't submit. Oh, we submit it whenever we get through writing it.
Well, I mean, when you go in the first day, he's mild, you say, or he could be a kind of John, give him the mic.
Hey, look, the question is, does he submit the order?
When?
Well, no, we don't submit. What happens is that the judge issues the order. You leave the courtroom.
Okay.
All right? With the court reporter, you order a transcript. She gives you the transcript.
Okay.
Okay? Then you sit down, you analyze it. Huh?
Just tell him how to use the mic.
Well, he's not talking. I'm talking.
No, me. He wants me to use the mic.
Yeah, but you're not talking. I was.
I know.
Okay, so, you know.
I'm using it.
Okay, yeah, all right. But look, you get the transcripts, you analyze it. It might take you a month to come back with the order vacating his order.
Okay.
All right? I mean, you do it sensibly.
Okay.
Yeah, you don't let this thing rush you.
I just wonder how prepared you have to be for these things.
Prepared enough to be able to sit down and study it and analyze it. There's no time limit on this. By the way, I want to inform you that the court moves at its own speed. Those time requirements are only for the litigants. When the court makes a decision, the sovereign of the court, and issues a court order out of the court against the judge, that's whenever you're ready. But I've saved you a lot of time, okay? You've been saved a lot of time and a lot of work because on this example, we've got a lot of the writing already done. You can lift it off and just plug it in, all right? You cannot lift it off and plug it in blindly. It's got to make sense. But I've saved you a lot of work now, okay? So anyway, feel free to use it. That's why I put it there. We've done a tremendous amount of work on this, and we've had fun with it.
Who's we?
Well, it's not my case, actually. I wrote all the papers, okay, but it's our case.
You're working with an attorney.
I am?
No, I don't know.
He's working with a client.
What they call it, client.
No, I have no clients. Okay?
Oh, you have no client.
No.
He's working with one of the people.
All right, this guy, he got injured on the bicycle. Okay? So he's suing. And then we had all this, but we're working together. Yeah, it's a team effort. Sure. And this guy was shrewd. The victim was shrewd. He said, I got all the time in the world to do it right. He says, he was in accord with me. The reason I agreed to help him was because he was of the same mind. We're going to produce something that people can use as an example. That's always a question. The question everybody asks me eventually, somewhere along the line, one way or another, is, did the judge go along with that? Okay? Well, read the transcript and decide for yourself whether or not he went along with it. It's fun reading at some points. Okay? Yes, he went along with it. Why? Because we were solid. All right? We didn't just issue an order saying, hey, we outrank you. No, we put in some real case law, some real statutory law, which he could look at, and although I'm not subject to it, he is. He takes an oath of office that subjects him. Okay? He has to respect it. And he said so. He said he had to follow the California rules. Well, great. We're glad to know that. That's why we convicted him under California rules. Okay?
Did you set a precedent with that case?
No, it's not a precedent because precedents only come out of the appellate courts and the Supreme Courts. And this is, when you're in a sovereign court, you're not in the system. You're out of the system. A common law court is a court outside the Constitution. The Constitution acknowledges the existence. If you look at Article Article 3, Section 2 of the United States Constitution, it says the judicial power of the United States is available for in all cases in law and equity. Okay? So if it arises under the Constitution, but we sue outside the Constitution, okay? Because I'm one of the people. I'm up above. I'm one of the creators of the country, or I'm in that class. So as that class of human being, I have, I create my own, I decree my own law. You see, the other side can ask for a jury, and if they ask for a jury, one of the jobs of the jury is to determine the validity of my law. That's why you have jury nullification. See, I can say, I can make it illegal by my law for anybody to wear pink shoes in my presence. And if anybody does wear pink shoes in my presence, it's a death penalty, okay? I mean, this really affects me. It torques me out, all right? So if somebody does, I can bring charges against them. Now, what do you think the probability is that we can gather up a jury if the defendant wants a jury, and I suspect he will, considering he wouldn't trust me as a tribunal, all right? But if he were to ask for a jury, what do you think the probability is that the jury would think that my law is reasonable? Okay? Pretty close to zero. But take the other situation. Walking along the street, minding your own business, somebody comes out of nowhere and plows me in the eye and gives me a nice shiner. Okay? I didn't even know who he was. I didn't even talk to him, didn't even look at him. It just came out of nowhere. And then I decree, my law is that he should go to jail for 30 days for assault or for battery. Okay? And if he does that and he asks for a jury, what do you think the jury would do? You think they'd convict him?
Give me a year.
Well, whatever, but the point is that, you see, this is the great genius of the common law system, is its custom and usage. And if you make your lawsuit in line with custom and usage, you will get the backing of the jury, because that's what they believe. But if you don't, then you won't. Okay? Okay, minutes or seconds? Minutes. Okay. So the common law is a great leveler of fraud and all the other problems of courts. And so that I believe in it, obviously. Any other quickie questions? We're running out of minutes. All right, I guess we're going to break up. All right. One more. Quickie.
Just, it's a thing. With the Black's Law, you said the fourth edition addresses common law and the fifth edition...
It's stripped out, right. Fourth edition and earlier is real law. Fifth edition and later is policy.
Okay.
Okay? And so that's what, I like to have both, because I want to know what the attorneys are supposed to know according to the power structure, and then I want to know what the real law is. And I also use Bouvier's Law Dictionary, which I don't know if they're still selling reprints of it at America's Bookstore in Sacramento. But you could check there. They used to sell Bouvier's Law Dictionary for $80. I think they raised it to $120 now. And so there we are. Okay, I think we're out of... Oh yeah, in La Palma. Do they have reprints?
I don't know if they
No,
have them,
this was done by the bookstore in Sacramento specifically.
And fourth edition Black's Law?
Well, you got to hunt through the used bookstores for that one.
They're available.
Yeah. Okay, I guess that. All right. Thank you. Thank you. Now, I think the restaurant officially closes at 9.